The city desires to accommodate persons with disabilities. Accordingly, any physically handicapped person pursuant to Chapter 286.26 Florida statutes should at least 48 hours prior to the meeting submit a written request to the chairperson that the physically handicapped person desires to attend the meeting. Any person who decides to appeal any decision of the Code Enforcement Board with respect to any matter considered at this meeting will need a record of the proceedings, and for such purpose may need to ensure that a verbatim record of the proceedings is made, which record includes the testimony and evidence upon which the appeal is to be based. Any person or defendant who requests to review or object to any exhibits presented to the Code Enforcement Board by the City of Titusville prior to submission to the Code Enforcement Board must stand and state their request to review the exhibits prior to review by the Board at the time their case or agenda item comes before the Board for hearing. Any person found to be in violation of the City of Titusville's Code of Ordinances and given a time frame in which to comply shall, upon compliance, be responsible for contacting the Code Enforcement Supervisor for an inspection to verify said compliance. The violation will not be considered to be in compliance until the Code Enforcement Supervisor is notified and verifies compliance. Okay, I call this meeting to order. Maybe stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. And we have a quorum. Oh, hey, Gina. Would you like to swear in the swear in the officers?
I will. Do you swear or affirm that the testimony you shall give before this board shall be the truth, the whole truth, and nothing but the truth?
Okay. Everybody had a chance to look at the minutes from the last meeting?
I move we delay the approval of the minutes till January.
May I ask why?
Because we haven't had a chance to read all 24 pages.
Is that doable?
There's no problem with a delay because each member should have an opportunity to review the minutes before voting on the propriety of the minutes.
Do you need a vote on that?
Yes, I would.
Okay. It's been suggested that we delay the approval of the November minutes till next month, in January. Any discussion? Second?
Second.
Roll call vote, please.
Member Ozon?
Yes.
Member Richardson?
Yes.
Member Edens?
Yes.
Member Beckles?
Yes.
Member Grant?
Yes.
Member Moniz?
Yes.
Chairman Bell?
Yes. So moved. The minutes from November 2017 will be delayed for reading and approval until January 2018. Old business. Ms. Chelsea, you're up.
Good afternoon. The first case on your agenda is number 1689 for the property located at 503 Cheney Highway. And this case is not in compliance for the violation that was cited for 656 permit required. The board has previously found that this violation exists on the property and ordered the defendant to bring the property into compliance by June 12, 2017 and reserved the cost of $482.19. I have Officer Crisco here to provide any testimony regarding the status of the property, and we also have an owner and her representative in the audience to make a request to the board for additional time to bring the property into compliance. I will turn the mic over to her at this time unless the board has any questions for staff. Seeing none.
Yes.
Ms. LaPalm, your full name is Leslie LaPalm, you're president and co-founder of LaPalm Enterprises, LLC, correct?
Correct.
Please proceed and direct your comments to the board.
Thank you. Good afternoon. I'm going to make this brief to the point.
I'm just going to give a summary. I purchased the property in 2014. The building was an eyesore. We made it look great. We made improvements to the property to protect our property. We did a few things. What prompted that was I had a loss of $5,000. A golf cart was stolen off my property. Then in May of 2016, one of my competitors filed a complaint with code enforcement. My business has grown exponentially, and as we grew, we made plans to further accommodate our growth. We hired engineers, architects to facilitate this. We worked with the City of Titusville Building and Planning Departments. From then till now, sadly, we have been unable to move forward. To date, I've spent in engineering fees $5,600, about $1,800 to the City of Titusville for plan reviews. Total cash, $7,411.50. In addition to spending the cash, the hard-earned cash that I make in my business, I've also spent valuable time away from my business. We realize that this process is no longer for us, but it's against us. We unknowingly placed our trust with people who were experts in their field, and these experts let me down. It seems every time we tried to take a step forward towards our goal, we were turned away without direction and what to do next. The turning point for us came November 29th, 2017. We submitted our response to questions received from planning, as the professionals we had hired had not provided a timely response, and we were trying to do the right thing. The return email from planning stated that our response would not be accepted and would only be addressed when submitted by an engineer. That was a very strict requirement, which we were really unaware of. So we were unable to hire an engineer and submit a timely response. It was very discouraging to us. The next day I had a meeting with my key management staff. Actually, my operations manager is with me here today. And we all came to the same conclusion, that we need to fight in a different direction. To facilitate this, I immediately took steps. We accelerated our search for a larger facility, and we are currently under contract to purchase this building. We will remove the violations from the property. What I'm asking the board is to understand that the move is going to take an amount of time. The time you grant us will be time we use to remove the items that need to be addressed. We're approximating that this will take 6 months to complete. In that time, we will provide the board with regular updates as to our progress. In addition to the time request, I'd also like to request the use of a temporary fence so that we may protect our assets in this transition period. Thank you.
When did you apply for the building permit?
May of 2016.
What's the closing date on your contract for the new property?
It is, it actually got moved today, March. We're hoping at the very end of March.
So you applied for the building permit 18 months ago?
Mm-hmm. And I never received a response on it. I got shoved over to planning, and that is where it remained.
What's the status on that right now?
Pardon?
What's the status on it? Sorry. What's the status on?
Status on that is, as I said, I did hire an engineer. We submitted site plans. Round 1 and round 2, I got first a group of questions, which were initiated from the first site plan submittal. Then from there, I had a second group of questions. It just keeps growing. The questions kept growing. So my engineer let me down on the second round of questions to be responded to, and I just said, that's it, I'm done. We then said, fine. So me and my operations manager responded to planning all the questions they had on round 2. We immediately got that kicked back, and we were told from planning, no, we will not address you cannot provide me these questions. They must only be through an engineer. That's the only way we'll accept questions answered, which to me I thought was kind of ridiculous because I'm the owner of the property. But that's what we did, okay? So I said, we talked about it, and we said, you know what, this is getting ridiculous. So that's immediately why we accelerated everything, and that's why right today I'm under contract on another building.
About how long is it going to take you to move in this other building?
I'm guessing it's probably going to take, I do have to renovate it, and I have to do a few things. By the time I close...
You are getting a permit for it, aren't you?
Pardon?
You are getting a permit for it. I'm just kidding with you.
Pardon?
I said you are going to get a permit for what you're going to be doing to this other building.
Well, of course.
Yeah, okay.
Well, of course. Of course.
Okay.
I'm not going to disclose the location, though. I'm not going there. I'm under, just so you know what I've done, between the seller and myself, we have a confidentiality agreement. I'm not releasing the location of the building.
But
Is it going to take me about 6 months?
but in the meantime, the violations that are currently on are currently,
Well, there's one of them that we're trying to, the reason I asked for the temporary fence is because that's one of the violations. And I'm trying to remove that from the property. That's why I'm asking for a temporary fence.
well, that's not up to us, that's up to someone else. about
Okay.
the fence.
Well,
We
that's
can't-
what I'm going to do. I'm asking for a temporary fence.
All we have it for.
I'm
To
trying
answer that question, this
required.
board does not have the ability to grant any permit for any temporary fence. That's an application that you make in writing to the building department.
Yes, I know, that's why I said
That's
so.
fine. But I'm trying to make this right, is what I'm trying to say. And I was here, I don't know, I don't remember what meeting it was. When I said, go ahead.
I'm sorry. All we're looking at is permit required. Nothing about a temporary fence, nothing
nothing-
about anything
we have
else.
nothing to do with
Just
that. That's
permit
something- that's
required,
something
and that's
new.
it.
The permit required,
Yeah,
she filed 18 months ago.
that's why I said that the violations that are currently on are, it will still be there in the 6 months it takes for it to move to a new location. Am I correct in that?
So to date, you've not received a permit? You applied for it,
Yeah, oh, absolutely.
and you have not received it?
No. I got bumped over to planning.
If I could make a correction, the application was not completed as far as requesting a application for a permit on this site until August 14th, 2017.
No.
The application that was
No.
initiated by Honeycutt and Associates was
No.
started on June 9th, but its submission was not complete until right around that time of the August Code Enforcement Board meeting when those permits were paid is when that final application was complete.
Did you say there was an application for the application?
There was a pre-application meeting with the owner of the property. Pre-application is the term that I used.
That also is incorrect because I met with Steve Adams immediately right after that. I want to say, what was it? May was when the complaint was filed, and then I want to say in that time frame, I met with Steve Adams of the building department, and I submitted a formal building permit, and there was no action taken on that. I was immediately bumped over to planning. And that's on record with the building department. So did I apply for a building permit? Yes, I did.
So we have an option here to find that there was a violation for the permit, assess the cost for the city, and give 6 months for her to move. And then if for some reason there's still an issue at that point, I think what we all have a hard time with is the planning and them working together. Obviously, someone's holding the process up as well, with both of them. So if we did that, then at least there wouldn't be a daily imposition or monthly imposition until that point. But of course, we wouldn't want to see it go past 6 months. And our point is compliance, yes? So could we be happy if it complied within the next 6 months?
Are we going to get any testimony from planning or from anyone else in the
We have several times already.
We've had testimony from her also several times.
For the benefit of the board, you've heard the presentation of the defendant, Mrs. Lapone, on behalf of her company. We need to hear from the city as to their response to the defendant's request, and then make your consideration as to hearing from both sides. So, what says the city regarding Ms. Lapone's request?
The city is in its same position as it has been throughout this year, where a permit is required. I have previously brought planning staff and building staff to this board to provide a status of what has changed. At this meeting, there has been no change from previous presentations. There has been no permit that has been obtained. There has been continuing conversations between the owner of the property, as she has disclosed to you, and the city staff has responded. But after that first site review of comments that was presented to Rodney Honeycutt on August 30th, the response has not been deemed accepted by the city. The comments that were generated from Ms. Lapone indicated things such as, we're going to change the site plan, but no site plan accompanied the response. And so the city was unable to adequately review the response that was provided in November because it did not include the things that it referenced within the very response that was provided. And so if the response says, I'm going to give you a site plan, how can the city evaluate that statement?
Before we go into further recapitulation of what we've heard many times already, this defendant is required to have a permit for improvements or changes to the property. Is that correct?
That is correct.
And the defendant has made changes to the property according to the city without a permit, correct?
This board has made a finding of fact that there is that violation occurring on the property.
Mrs. Lapone.
Yes.
You've heard the words of the city.
Yes.
You don't have a permit. You have made improvements or changes to your property without a permit. What are you going to do with your property that you own where the alleged changes have been made without a permit? Not concerned about what your future endeavors are with some other property. That's your prerogative to do
Correct.
as you please. What are you going to do with this property that you have made changes allegedly to, as determined by findings of fact, without a permit? When are you going to either acquire a permit or return the property back to its condition it was in before this all started?
I am going to remove I just said that in here. I'm going to remove the violations.
When?
I need 6 months to do that.
Why?
Because number one, I still need to run my business, number one. Number two, I need to move my inventory. It needs to move to a secure location, and that is going to move into my new building. I can't just leave my stuff out in the open, and I need to operate. It is my source of income. That is how I make money and pay my bills, keep my people employed. And I need to move that operation to another building. I'm already under contract, and I am spending a ton of money to move to another building. This is my livelihood. This is not a joke for me. It is not a joke. And
Rod Honeycutt failed to submit the second set of responses.
Correct. So what we did
You had a meeting where everyone agreed, and
I
it
would
was just...
recommend the board not go back into what the defendant did or didn't do with other departments of the city. That is between the defendant and other departments of the city. This board cannot address what you're bringing up as to your problems of life with other city departments.
But hold it. What the city just stated, it's making it sound like I didn't do anything. Where really I did. I made a huge attempt. To me, spending $7,400 is a lot of money. And I spent that money to attempt to make that property come into compliance.
Ms. Lapone, your testimony is clear. You're moving on, so to speak. Why is it going to take 6 months? Or city, what do you have to say to her request that it's going to take 6 months to return the property to its original condition before she took action on that property without a permit?
After the amount of time that this case has gone on, it is up to the board to determine any additional time frame that is appropriate to bring this property back to the original state it was in prior to this code case.
Okay.
Yeah. Yeah.
Do you wish to respond?
You asked what would take so long? I have to go through financing on a building. Financing on a building these days takes a good amount of time.
But there are additional storage options, other alternative storage options.
I don't have any other options.
The issue before the board is if you're not going to pursue your permit on the particular property we've been discussing for a very long time, what is required to return it to the condition it was in before you made changes to the property? You just said it's going to take 6 months because you need financing. What do you need financing for?
To buy my new building.
To put on the new property?
Pardon?
You were talking about buying new property the end of March. Are you needing financing to buy a building?
Yes.
Or to build a building on the new property?
No. I need.
What has that got to do with the problem we have before this board? You keep
Well, I
going
need to
someplace
move-
else. Let's stay on the property before the
Yes,
board.
and I need to move my stuff. My
What
stuff.
What stuff?
My inventory.
Mm-hmm.
My inventory needs to move. Right now, I don't know, have you driven by my property at all?
Ma'am, we don't go investigate your property. We listen to testimony.
Oh, okay. So on the one side of my building, they're calling it a fence or whatever they're calling it. On one side of the building, which would be the east side of the property, okay, I have an area where I have golf carts outside. And we put up a structure. And that keeps my golf carts safe. Okay? So in order for me, I will take it down. I don't have a problem taking it down. That inventory that I have sitting there, those golf carts, they need to move somewhere. I'm going to move them into my new building. I just don't have anywhere to move them right now. That structure's coming down. That seemed to be an issue.
So that's what's going to take you 6 months, and you don't have any place to put your golf carts.
I don't have anywhere to put them.
We need specificity. We've talked and talked and talked.
Oh, I'm tired
for
of
over a year.
honey,
Well,
I'm tired of talking.
as are we. So let's
I'm
get
up to
down
here.
to it. Either get it back the way it was within a reasonable period, or pull a permit, or start being fined. Those are the only choices.
To me, a reasonable period. I have accelerated my building search to a point where I really didn't think I was going to get it done. And everything is just really falling into place for us. And it's working. And I'm going to get this done. And that's the time frame I need to get it done. Because I have to go, this is just so you know, I have a new building. I need to go through financing on that building. That's where I'm at with it. Am I under contract? Yeah. Is the financing going to happen? Of course it is. I just need the time to do it. Because I can't leave my inventory, I can't leave my golf carts hanging around outside. I'm getting batteries stolen out of my golf carts as it is. Just so you know. That's what's going on. My forklift batteries got stolen. Golf cart batteries are being stolen. It's ridiculous. Really?
Anything further?
No, I'm good.
Board, you need to determine, the city has presented their case. The board has previously determined that there was activity on the subject property without a permit. It's the board's purview now to determine whether or not you wish to continue this case further or determine a reasonable order to compel compliance by returning the property back to its original condition or pulling the permit. You get to set the timeline. Mrs. Lapone has given her justification as to why she believes she needs 6 months at this point. It's your determination now to move forward as you deem appropriate. You already have made a findings of fact of violation, so it's now either grant continued time because of the hardship she's expressing regarding her new plans for her change of business plan, or otherwise. Your decision.
Mr. Chairman,
Yes, you ready?
I am prepared to make a motion on this.
Go ahead.
Okay. I move that the board issue the following finding of the fact in case number 16-89 relating to the defendant, Lapone Enterprise LLC. The defendant continued to be in violations of the following section of Code of Ordinance of the City of Titusville on, what's today's date?
December 11th,
December the 11th, 2018.
17.
2007, I'm sorry, I just changed this over here. 2017. Section 6-56, permit required.
Second.
Who's second, Gina? It's been moved and second. Motion made by Ed, seconded by Gina. Any questions? Roll call vote, please.
Member Richardson?
No.
Member Edens?
Yes.
Member Beckles?
Yes.
Member Grant?
Yes.
Member Moniz?
Yes.
Member Ozon?
Yes.
Chairman Bell?
Yes. Motion carried. Next motion, please.
I move that the board issue its final judgment assessing fines and imposing liens relating to the defendant, Lapone Enterprise LLC, based upon the finding of the fact issued this date, and that the judgment contained the following provisions. The defendant is assessed in order to pay $75 per day for each code violation. The fine shall commence, what date can we use on that, Attorney?
It's up to you in your motion to decide what date. It can go backwards in time to when there was a finding of violation, but in fairness to the defendant, there's been a lot of continuances and going back and forth. Although you have the lawful authority to go back to when the violation was originally found to be in violation, you originally gave until June 12, 2017 at 9 a.m. to achieve compliance. You can go back that far to impose a fine of up to $250 per day, or you can commence presently, or you can wait till sometime into the future due to the hardship the defendant is indicating she's having with her business. That is the purview of the board to decide how much and when.
Okay, the fine shall commence on June the 12th, 2017, and shall continue until the code violations have been corrected to written satisfaction of the Code Enforcement Office. We have got reserved administrative costs of $409.51.
Nope.
$482.19.
$482.19.
I'm sorry, $482.19. She's ordered to pay $482.19 for the reserved cost.
So if my understanding is that she will not be fined per se until the 6 months is up, but she will be,
No, he started it 6 months
I
ago.
went back to
I thought
the
you said
original.
18.
No,
No, I went back to the
2017.
original
okay.
when we found this case in violation.
I agree because in my opinion, nothing has been, nothing will be done in the next 6 months to address the violations that we currently have.
You could start it today and motivate her to actually do something here, to tear down the structure and find a storage alternative
That's
instead
correct.
of going retro all the way back to June.
And she can always come back inside of here and ask for reprieve on us all,
I'm sorry?
on the fine and the cost.
I don't think she can come back. Once we order this, it's done.
Attorney Rogers, can she come back and ask for, to roll back on the fine?
The defendant can always request a rehearing for the board to reconsider certain actions it's taken. But I wouldn't base your decision on her having the ability to ask for rehearing.
Okay, no, I wasn't sure, I was just leaving that open. Okay, it stands as it's.
All right, so,
The fine should either be started back in
On
June
June.
or today.
June the 12th, 2017 was when we originally found this case to be in violation of permit required. I'm sorry.
And I don't think that's true either. That's the date that we gave her to come into compliance, so we had to have heard it before then.
That's correct. She had gotten a month then to come into compliance, and she has not come into compliance from that point to this point. So it's been 6 months where it has not come into compliance.
And my only argument for that is that it seems like she's made a valid attempt to work with planning and with the city of Titusville to get this permit issued, and spent plenty of money to try to attempt to get there. I'll have a hard time voting to go retro. I could go for today, but I'll have a hard time going retro.
Okay.
leave it stands?
Stands.
And you, who seconded?
No one?
Second?
Motion made by Ed, I need a second.
I'll second.
Second by Sandra.
Did you amend the start time?
No.
So you're still going back to June?
Staying with the start time and
Okay, motion made,
I'm sorry, I thought you were saying that you were gonna start the,
okay.
I thought that the decision was that.
What is
No,
it?
it's-
The fine
no,
as of
starting back
today.
June
As of
2017. Not today, June 2017.
We
So
have
do you want a
discussion
minute?
on this?
Yeah.
Well, we're having
Okay.
it.
What would you like to see for a start time?
Today.
Today,
Today?
today.
Today?
Today.
Today?
Mr. Moniz, either make your motion and
Okay.
stand by it or amend your motion.
Okay, sure.
Yeah.
I'll amend it to the starting time of today, December the 11th, 2017.
Second.
Second.
Motion made by Ed, second by Ashley. Any discussion? Any further discussion? Roll call vote, please.
Member Edens?
Yes.
Member Beckles?
Yes.
Member Grant?
Yes.
Member Moniz?
Yes.
Member Ozon?
Yes.
Member Richardson?
No.
Chairman Bell?
Yes. Motion carried. All right, Ms. LaPone, you'll hear from our attorney, Mr. Rogers, as to the determination of the board.
And how will I get that? By mail?
By mail?
By mail?
Yes, ma'am. In about 10 days to 2 weeks, a decision will be rendered in writing by the board based upon the decision just made. Do you
Okay.
have any questions regarding the decision of the board?
Yes.
What's your question?
What, explain to me, what is the rehearing and what is the appeal procedure?
The rehearing proceeding would be for you to request the matter be placed on the agenda for the board to reconsider a prior decision of the board. So you would request to be added to the board agenda for the purpose of reconsideration or rehearing of a decision of the board, which you have the prerogative to do. If you wish to appeal a decision of the board, you would want to get a verbatim transcript of the record, and there is a statutory appeal procedure to where you can appeal to the circuit court of the 18th Judicial Circuit for an appellate review of the decision of the Code Enforcement Board. You'll need, I would recommend you consult with an attorney in that regard because it's a bit on the technical
I know
side
it
as to
is.
the requirements
I've
to
been through
file an
appeals
appeal.
before. I understand appeals.
Okay.
Okay, that's all I needed to know.
As to your request for rehearing, I would recommend that you give more detailed information regarding the timeline for you to achieve code compliance. As you have pointed out many times, this process has taken well over a year. So it's been going a long time. It
And
needs
through
to
all
be
this,
resolved.
I only asked, from what I can tell through my records, I asked for one continuance the whole time. Once. That was it. So, all right, are we good?
That's all.
Thank you.
Next case, please.
If you don't mind, I'm going to take a couple of cases out of order to accommodate some folks that are here in the audience.
Okay.
I know that the owner representative for case number 17-37, the property located at 505 Short Street, is here with us today. The city's records indicate that this property had obtained a building permit, and that building permit was recently extended to allow activity on the property through May 16th, 2018, and the property is still in violation. However, that permit is active on site, and I will allow the owner or representative to come and speak to the board at this time.
Chelsea, which case are we on again?
We're on case number 1737, third
Page
listed.
3. Top of page 3.
And did you say that something is in compliance?
No, it's not in compliance. However, there is an active building permit. The property continues to be in violation, and I have the code enforcement officer here to provide testimony if you'd like to hear from him.
Okay.
But we'll see what the owner or representative has to say.
If you'll raise your right hand, please. Do you swear or affirm that the testimony you shall give before the board shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Your name for the record, sir?
Clyde Botner.
And are you the owner of Clyde Botner Incorporated?
Yes, sir.
That's
Yes,
a
sir.
Florida corporation?
That's correct, sir.
Mr. Botner, please direct your comments directly to the board, but for your benefit, if I may, your case came before the board some time ago. For the board's benefit as well, this case was first heard on April the 10th, 2017. At that time, the board continued the case until July the 10th, 2017, unless the alleged violation of Section 1 or 6-109 Property Maintenance Code, subsection 108.1.1, unsafe structures, was corrected or resolved. On July the 10th, the board rendered a decision again continuing the case until November the 13th, 2017. As the board was informed, your company or you had obtained a building permit that would expire in November 2017. This case came before the board on November the 13th, 2017, and the case was again continued 1 month, and here we are. So if you will now proceed and inform the board what you feel is relevant to this case pending before the board.
Yes, sir. I just want to have time to fix the property, and I had the permit. I've got the water turned on, and I'm real close to getting the power turned on.
What's the unsafe structure that we're talking about?
I'll have to invite the officer up for testimony.
The unsafe structure is the structure itself located at 505 Short Street. There's holes in the roof. There's no floor in one part of the building.
Those are two of the things that would bring it into compliance. Is there anything else that would need to happen before it was compliant?
There's a long list of things that would need to be done before the building is in compliance. The roof and the flooring are just two items.
So turning on the water and the electric has nothing to do with the violations?
No.
It's my understanding that the owner previously represented to this board that he needed to pay substantial water liens in order to get water turned on to the property, and that was an investment effort that he had been making in order to repair this property. And he would be able to speak to that. But Officer Lewis, have you had an opportunity to inspect this property and meet on site with anyone to go over the items that need to be corrected?
No, I have not. The actual last time I was at the property was last month, right before the last code board.
Okay. And so I would recommend that going forward that the code enforcement officer meet the owner on site to outline exactly what needs to be done to cure that unsafe structure.
Absolutely.
Is the structure secured, like,
As
is
of
it
the last
open, or
time I
can
was
people
out,
get
it was
in and out
secured.
of it?
Yes, ma'am.
It is secured, though?
Yes, ma'am. As of the last time I'll take that back. There was one window in the back that was not secured.
Is this a residence? Is this a commercial building? Is it a storage building?
It's a residential structure. Or it
residential
was.
structure.
Property is zoned commercial. I mean, residential, I'm sorry.
And he seems to be making progress, or you
Officer
say you
Lewis,
haven't,
has
you
there
said
been
you
any
haven't been there,
progress
right?
at the property?
I have not seen any.
You haven't seen any?
But he hasn't been there since before November 13th.
Correct.
What date was the permit issued and did it expire?
1 second.
July 10th? Is it July 10th?
The permit was initially issued on May 1st, 2017. It was applied for in April and then issued on May 1st when the applicant came to pick it up, and it was reissued good through May 16th of 2018 as of November 1st when it was expired. He came in and renewed it.
When does it expire?
May 16th, 2018.
Still got about 6 months left, or 5 months left on it.
So after the permit had been in expired status, the applicant had the ability to come in and pay a fee to renew it, and that's what happened on November 1st.
In the past, we've seen cases where some violations were allowed while there's an active permit in place. Is this part of any of that whatsoever?
Sometimes we treat cases differently if the property is a nuisance or a threat to the public and it needs to be boarded up or some corrective action needs to be taken. The testimony from the officer that you heard is that this building is secured enough that no action needs to be taken at this time. And we do see that there is active participation from the owner by getting this building permit, and that is why we hope and expect that the property will be corrected during the time frame that the permit is active.
Do you know if we gave him 5 or 6 months whenever we gave him the?
I see that in my notes that this case was previously continued from July, but I don't know exactly how many months you gave them at that time, but I believe that it was related to in June when you heard this case, you would have seen that there was a permit that was issued and would have given them 6 months until this time frame of the year where you would readdress the situation and at this time decide where you are going to go with the violation of unsafe structure, which does exist on the property. You have not yet made a finding of fact on this, and it is up to you to determine how much more time is appropriate before you make a finding of fact, knowing that there is an active building permit that allows the owner the time to correct the property as the code requires.
Is there any reason why we don't have costs reserved on our
I haven't made that initial, you haven't made that initial finding of fact, and so at that time where...
This is like the first reading, so it's not even on there yet.
Okay.
So this is almost like new business.
This is like new business, that's correct.
Okay. All right.
The difference is just that there is an active building permit that has been obtained by the owner. This is the only thing that sets it apart from any other case.
Okay.
Yeah.
Could we talk to the gentleman again?
Mr. Botner, is that correct, Botner?
Yes, sir. Yes, sir.
Right, about how much time are you gonna need to get this building's back into shape again, roughly?
February.
Can you repeat that?
February.
Until February
So you're asking-
2018?
You're asking us for, 2 months?
Yes, sir. Yeah, I'll definitely make an improvement, get it straightened around by then. I don't know if I'll have the permit finalized out by then, but I'll definitely make sure the holes in the roof are corrected and the other, whatever's violations.
You had previously stated you were trying to catch them on the water bill.
Yes, sir. Yeah.
How much approximately was owed?
A little over 3,000.
3,000.
Yeah.
Okay.
And that's all paid, and I've been paying the water and the trash bill and all that comes just like as if somebody was living there, so that's been paid.
So as far as the city of Titusville is concerned, it is up to date.
Yes, it is, absolutely, yeah.
I haven't reviewed the water record, but the concern here before the board is the unsafe structure and nothing else.
Well, he says he can't improve the unsafe structure until the water's turned on.
Well, I got it, the water is on
Okay.
now, yeah, in other words, it's just, that, and then my electric, it's so much easier to work off the electric than the generator.
How long have you owned this property?
I probably bought it 3 years ago.
I say we have two situations, the property maintenance and the unsafe structure.
Yeah, that was corrected a long time ago, like when I first bought it. Or I don't know what you're looking at there, but
So,
But this is really
This
just
is-
one violation, right? A subsection is just, it's just one violation.
oh, I see, okay, thank you.
I would make a motion to continue it for 2 months.
Yeah.
Well, the building permit doesn't expire for
Till
6
May,
months.
yeah, right. But he says February, so, why not let him come back in February and let us see that we've made progress and
Tell us how he's doing.
yeah.
Okay.
All right, who's making the motion?
You got it.
I make a
First-
motion to
no.
continue
Okay.
for 2 months.
Second.
Motion made by Ashley, second by Gina. Any discussion? None? Roll call vote, please. She's second.
Member Beckles?
Yes.
Member Edens?
Yes.
Member Monis?
Yes.
Member Ozon?
Yes.
Member Richardson?
Yes.
Member Grant?
Yes.
Chairman Bell?
Yes, motion carried.
See you in February.
Mr. Botner, you'll be hearing from Mr. Rogers. You'll get an extension for 2 months, so it'll be February.
yes,
So hopefully we'll see you with good hopes in February.
yes, thank you very much, I appreciate
Mr.
that.
Botner, for your and my benefit, since I don't have a 2018 calendar before me, what is the hearing date for the February board meeting? So
Well,
Mr.
I'll tell you in just
Botner
one
will
second.
be aware.
February
it'll be
the 12th.
February the 12th.
February
the
when?
12th, sir.
11?
12.
12th, okay. Mr. Botner, February the 12th, 2018 at 2 o'clock is the next board meeting. If you have resolved the alleged violation of an unsafe structure on your property prior to that date, you should contact the code enforcement officer and have the officer inspect. If they confirm code compliance, they will notify the board accordingly, and this case will go away.
Yes.
If you do not have code compliance achieved by February the 12th, you need to appear before the board and say whatever you need to the board, as the board will then determine if there is a code violation and whether or not a fine or cost should be imposed.
Yes,
Any questions?
that, I understand correctly.
Okay.
Yes,
About 10 days to 2 weeks, you'll get a written order in the mail.
thank you,
Thank you, sir.
Thank you.
Thank you.
all right, thank you.
Chelsea, where you want to go to next?
The very last case listed in your agenda, under new business. We have a member of the audience present here on case number 12-211 for the property located at 4850 Walton Avenue, and I've invited Officer Crisco here to provide testimony for this case. Officer Crisco, did you have an opportunity?
I don't think that's the right number.
She just misspoke. It's 17-211, not 12-211.
I'm sorry.
No problem.
The last case listed on your agenda
And that's under new business?
That is under new
is
business.
under new business.
17.
Right before board attorney's report. Case number 17-211, sorry if I misspoke. Property is located at 4850 Walton Avenue.
You did say 12, but that's no big deal. So,
Are we all at the right spot?
yes, yes, ought to be at this point.
Okay, Officer Crisco, did you have an opportunity to inspect the property at 4850 Walton Avenue?
Yes, I did.
And did you find this property in violation of the Titusville Code of Ordinances?
Yes, on August 28th of 2017. The following were, on the violation notice was Section 1811 nuisance pool. Under Section 6109 property maintenance, Subsection 302.1 exterior sanitation, Subsection 303.1 swimming pool maintenance, and Subsection 303.2 enclosures.
Okay, thank you. Did you provide notice of the violations to the owner of record by first class and certified mail, as well as posting the same on the property and at City Hall?
Yes.
And do you have the proof of mailing and an affidavit attesting to the notice?
Yes, I'm sorry.
Thank you. Please submit the proof of mailing and affidavit as to notice into evidence as Exhibit Number 1. And then did you reinspect the premises to determine if the property was in compliance with the violations as cited?
Yes, let's see. I talked to the owner on August 28th, explained the violations. He called back on 9/5, said he'll take care of it. On 9/29, I went back and I put the 1320, well, you don't see that here, the overgrowth was put into compliance. Nothing else was corrected. And we proceeded to code board on, let's see, 11/29. The property was still in violation. On the follow-up on 12/7, I spoke with the owner again, and he had a new property, a new screen enclosure. So on 12/8, we put that into compliance. And of course, that would have eliminated the 302.1 exterior sanitation.
So the city is withdrawing 302.1 exterior sanitation as well as subsection 303.2 enclosures pools.
And again, I talked with the owner in front of his house, and he refuses to clean up the pool.
What is the difference between Section 18-11 nuisance pool and subsection 303.1 swimming pool maintenance?
How do I know you were going to ask that? 18.1 nuisance pool is basically mechanical, and what it pretty much says that in service, all items designed for the purification of the water supply perform the function for which they are made to do.
Okay.
Swimming pool maintenance is just a green pool.
Okay. So nuisance pool is mechanical functions.
Yes.
And swimming pool maintenance is more like the water status.
Green, yes.
Green.
What's not working on the mechanicals?
The pumps operational?
Well, we don't know
at this
that
pool?
yet. We impose that they're not working because the pool is green. Unless the owner could prove to me with a inspection that the pool pump is working, then we just eliminate that violation. It's simple.
Did you say it is not working, or does?
He doesn't know?
He doesn't
know.
It has not
That's
been
on
proven
here,
to
even
the
if
written,
you don't know if
it hasn't been proven by an inspection of the officer that there's operational functions of the devices that are required.
Right now, it's not working because the pool is green.
Okay, I'm sorry. I'm just slow today. I'm just slow today for some reason. What violations have been corrected on here?
The exterior sanitation was withdrawn because when I went back on 12/8, he has a new enclosure.
Okay.
And
Does that take care of
303.2?
303.2 as well?
Yes.
303.1 is the remaining subsection, and 18-11 nuisance pool is the only primary code section, leaving 2 violations out of the original 4 that you see on your agenda.
But his question is, we're striking 302.1 and 303.2.
Correct.
Okay.
Would you like to show any photographs?
These were taken this morning, basically.
That's like snow.
Looks
Yeah,
cool.
there we go. That's just the front of the house to give you an idea.
Oh, that's definitely.
It pretty much shows the screen enclosure with the green pool. The screen enclosure is new, and that's a closer angle the other one was.
Please submit the photographs into evidence as exhibit number 2. And based upon your inspection, did you file a complaint?
Yes,
Did you issue a copy of the complaint and a notice of this hearing to the owner of record by first-class certified mail posting the same on the property and at City Hall?
yes, I did.
Do you have an affidavit as to this notice?
Yes.
Please place the proof of notice and affidavit into evidence as exhibit number 3.
Now, did you say that you asked the defendant concerning 303.1, and the defendant said he wasn't going to take care of it? Did I hear that?
I will allow you to ask the owner himself what his response is.
No, I thought Mr.
Did you
Crisco
speak to
said
the
something.
owner about?
Yeah, a couple of times. I already said that.
303.1?
I spoke with the owner. Got to listen. I spoke with the owner on 8/28 when I talked to him over the phone and explained the violation in detail. I spoke with the owner on 2 occasions within the past week, the last one being on the follow-up on 12/7 when he came out the door, and I told him what had to be done, and he refused to. He said, I ain't cleaning the pool.
So 12/8, he said he wasn't cleaning the pool.
Before we go any further, this code board meeting has to be kept civil. People mishear things, so let's keep it civil on all aspects. Thank you. Go ahead, Gina. Go ahead.
I was just saying, let the owner testify on his own behalf.
Although I think
If
it's
you
valid.
understand what I'm
I think
saying.
code enforcement can tell us what the claims that they've made as well. So, not that that's not valid.
Okay. As of this morning's inspection, did you determine if the violations still exist?
Yes.
And do you have a cost recovery statement detailing the cost incurred in bringing this case before the board?
Yes, I do.
And what is the amount?
$446.10.
Please submit the cost recovery statement into evidence as exhibit number 4. Does the board have any further questions of staff?
Before we let him testify, I just want to ask the board attorney, is that, so concerning 18-11, when we hear this and we're considering a finding of fact, is it proper that we use code enforcement's assessment and then give him the right to prove that his pump works? Or, I mean, can we actually determine this without knowing that actual fact?
You need to hear all the evidence that is presented that is relevant to the case. The city has a burden of proving their case. My recollection of the testimony is the city is presuming a violation of 303.1, lack of maintenance, pool maintenance, because the pool is green. So certainly the defendant or his representative has an opportunity to be heard. You are not constrained to one side or the other. You listen to all the relevant evidence before you make a ruling. I'm a little perplexed by your question. I'm not quite sure what you're asking me.
Well, I guess I just feel like it would be easier for them to determine, for the city to prove about a nuisance pool than the defendant to prove about the nuisance pool. And that, because, this is just verbiage from him today. We're never going to see the pool. We're never going to know anything else about it. But Officer Crisco's been at the property before, so wouldn't it be helpful if we tested the pump before we got here? Or, something like that, I guess. It would just be hard for me to determine that this pump doesn't work. Or does, for that matter.
Bear with me one moment because I need to review Section 1811 of the Code of Ordinances, nuisance pools.
Let me just say this while he's looking that up. If the code officer is proving his case, if the code officer has presented his case, and basically the fact that the pool is green substantiates the fact
That doesn't at all. I mean, it doesn't, though.
Can I finish, please?
Sure.
It substantiates the fact that That's the evidence that he's showing that it doesn't work. It's up to the owner to explain why, that it does work and to prove to him that it works. We're just saying, did he present his case showing that?
Thank you, Gina. I do believe that the evidence presented meets the evidence for both of the two different violations. And your board attorney may reiterate what I'm about to say, but I can try to further explain the difference between the two. From the International Property Maintenance Code side of things, the green pool is correlated to a statement that says swimming pools shall be maintained in a clean and sanitary condition and in good repair. That can be compared to the green pool being found and seen by the naked eye as not being clean and sanitary. Compare that to 18-11, nuisances. It's the owner's responsibility. It is the responsibility of the pool owner to see that the operation of his pool does not cause undue noise or excess lighting, which might prevent the enjoyment by adjoining property owners of their property. However, it continues to talk about the operation and the functions of the pool. It says, number 1, subsection under 1811 is, upon construction of a swimming pool, the owner or persons responsible for its operation shall keep in service all items designed for the purification of the water supply or its protection from pollution to perform adequately the function for which such were designed. So absent any operating pumps, how are we to know that that section is being complied with? If there was an inspection that showed a pump running, cleaning the pool, then that violation would be closed out, but that has not happened, and I've invited the owner to have an inspection at a time where the two could meet on site to see if that's happening, and that hasn't happened yet, but you heard from the testimony of the officer that he's attempted to see that working.
When if and when they can meet, is he able to ask them to show the pump functioning?
The officer it would be incumbent upon the owner to show that the pump works, yes.
If the pump worked, the pool wouldn't be green, bottom line.
Not true. Lots of people don't run their pumps. I mean, I don't know why.
I basically was there like 4 or 5 times, and I guess the code manager explained, I didn't have it in my notes. Usually when a pump is running, the water is moving around and the creepy crawler is pumping. I don't even remember if there's a creepy crawler, but you do see a circulation effect. Yeah, the pool could be off. But if the pump was operational, every time I was there, you would see the water going around.
As a realtor, I come across lots and lots of green pools that have functioning pumps. So that's all. I mean,
it has to have the ability to perform adequately the function for which it was designed. That's what our code requires.
Then they're in code violation too.
That's what I'm saying.
Okay.
but I can easily say hands down that the pool needs maintenance. I cannot hands down easily say the pump doesn't function.
We're not saying whether the pump functions.
Well, that's what this section 1811 is.
Let me say this. Okay, if you got stopped, if you left your wallet at home one day and you got stopped by the police officer, and you said, I have a driver's license, and the police officer said, you need to prove it, he can take that case to court and say that you were driving without a license. You would have to come up to the judge or to court or whatever and show your license, right?
Well, and that's kind of what I'm saying.
That's the same thing I'm saying. You still would get a ticket for not having that license until you prove that you have it, right? And that's the same thing that what we're saying here.
Okay.
Let's hear from the owner. Mr.
Your turn to speak, sir.
Is he going to be able to hear? Is he going to be able to hear?
Yes.
Do you swear or affirm that the testimony you shall give before this board shall be the truth, the whole truth, and nothing but the truth?
Yes, forever.
Please state your full name for the record.
Donald Dragonet.
Mr. Dragonet, do you own the property at 485 Alton Avenue, Titusville, Florida?
Yes. Yes, I do.
Please direct your comments directly to the board how you wish to respond to the city's accusation that you're in violation of the city codes, specifically codes subsection 303.1 swimming pool maintenance or lack of swimming pool maintenance, and section 1811 a nuisance pool. Please comment to the board what you have to say about what the city says.
I moved down in Florida here in 1964. I had a pool house for 25 years, never had a problem, never had a call. So I know how to take care of a pool. When my parents died, because I came down here to take care of them, the house was too big for just my wife and I. We realized our friends would be going down to Miami and stop over for a weekend and then continue. So it just got too big. Anyway, we got a smaller house, didn't have a pool. I got married and, my wife got macular degeneration. Sorry sometimes. And so it was she got a heart attack. Anyway, she died. And several years later, I got married and I moved into the house that I am now on 4750. And they had a pool, which I took care of fine. The gentleman was right. I did have some damage. After I got divorced, my wife was a lot younger than me. I did get some holes in the screen, and I wasn't as I didn't go swimming much, but I did maintain the pool. I had a meeting with several people to rescreen the pool, and I finally settled on what I could afford was a company that was going to do the bottom of the screening. It's 8 feet high, not the roof, because I wanted to protect myself from any child, even though I have a perimeter fence, any child wandering in the pool. Unfortunately, before I could get that done, something happened to me that don't even know what it is. I got a stroke, wound up in the hospital, and they finally dismissed me, but nothing went ahead with the screening because everybody was all upset. I lived with a lady that as soon as we get some things cleared up, we'll marry, and my brother-in-law. Anyway, I was home from the hospital for 3 days, and Irma hit, that's her name, that hurricane. Boom. All the screening went. So I gave up on the idea of trying to save some money, and I took out a loan, and I got the entire pool screened. The inspector came and said, "Oh," he says, "I see you patched up the screen." I patched it up. I see, I never get a toilet to this guy. He just comes and goes away. He never tells me what the heck is going on. Anyway, pool was done, and I also contracted the man who does the pool next door to me is also going to do mine. He will start on Wednesday. He does theirs Wednesday, so he'll do mine on Wednesday. And
this is a cleaning service?
Pardon me?
This is a cleaning service?
Yes, I got his card here.
And you hired him as of what date?
Oh, by the way, I have the 1-year warranty for the
screens,
pool screen.
I hope you don't mind my interrupting, but you know that we're not talking about screens today. All we're talking about is the water and the pump.
Oh, by the way, I had the pump rebuilt about 3 years ago. I was a master mariner for 4 years. Pumps are my second. Every boat has to have a lot of pump. Anyway, here's the name of the pool guy.
According to you, your pump works. It functions.
Works all the time, yes. So I don't understand what all of this is unless it has something to do personally with me. I don't say I'm an angel, but I've never been incarcerated.
Well,
What date did you hire the man to clean your pool?
Pardon me?
What date did you hire the man to
Every
clean your
Wednesday.
pool? Has he done it yet?
No, he's come here Wednesday.
So you have.
No, they just
happened.
finished. They just finished
Okay.
They just finished the screening Friday or something.
Mr. Dragon, why you're what we're talking to you today about is about the pool being green. It's not safe. It's not a safe environment. It's not clean. You're not running your pumps.
I understand that.
Okay.
I had my pool cleaned several times. It just so it happened. So, see, my property backs up onto undeveloped land, and after a while, it gets like a jungle. And I finally called Florida Power and Light because it backs up onto 3 foot of power lines, and they told me that maintenance is for the owner of the property. So I called them and I spoke to the secretary because I paid $100 for a guy to come in with a chainsaw, and he cleaned most of it away, and they put the stuff out in front of him, a big pile of stuff. So that's a lot cleaner than it. But now I have a picture of that after the hurricane came through. So somebody's got to clean that up.
Can I make a motion?
Not yet, not yet. But we're not talking about that today. We're talking about the cleanliness of the pool itself. When will the man be coming to clean the pool?
Wednesday.
W-E-N, Wednesday. I can't make it any clearer than that.
I understand
but
that.
I'll give you because I'm being treated not... Sorry.
Mr. Dragonette?
I can only give you with this, and I have never had any trouble with a pool in my life.
We're interested in the cleanliness of the pool. This is all we want to know. You said Wednesday. There's Wednesdays every week. Will this Wednesday?
I'm sorry, I don't understand.
Will it be this Wednesday when the gentleman starts?
Wednesday, yes.
Here, let me have your card, sir. Thank you. I'll be right back with it.
Okay, that's all we're wanting to know. Do you have any other questions?
Could make a motion.
Okay.
Wait a minute.
I move we continue it 1 month. We see if the cleaning service has started
I'm sorry.
they can arrange an appointment so that Officer Crisco can confirm that his pump functions.
Second.
All right, there was a motion made by Ashley to continue for 1 month, seconded by Mr. Remy. And you have any questions?
I have a comment.
Okay.
I think this total cost incurred of $446.10 is too much.
Well, it's because of the 8 field inspections.
8 field inspections.
But he keeps coming out. He had to come out to do the first one. He had to come out and see compliance for the overgrowth. He had to come back for 1129. He had to come back and do compliance for the screen. So, I mean, we're not seeing that there were several allegations here in the beginning.
But remember, we have yes, right, we have the option to reserve the cost.
But she's still saying that amount seems.
I don't feel good about this much money. $446.
May I interject for a moment?
Those are the
Did
costs
I
to
hear
the city to go. Those are
one
the
of the
costs to the
complaints
city
was
going back.
Go ahead, sir.
the overgrowth. That was from the
And you're in compliance.
backyard.
As far as we're concerned, you're in compliance. We're not here for that. You're in compliance with the overgrowth.
Thank you.
Yes, sir.
What did you find out?
I left a message for them. They did not answer the phones. Hopefully they can call back very soon.
Is it a local company?
Out of Melbourne.
All right, back to business at hand.
I made the
by
motion
Ashley.
a month.
And
Motion.
I don't ask for any special treatment or anything. I agree with everything that you say, but I've tried to comply. But it's like something else is going on that I don't know about.
It would be
Is
the
there
January
anything,
8th
some
meeting.
kind of an aura about me that,
No, sir. We're trying, right now, we're trying to make a motion to give you a 1-month continuation. And Mr. Kresko will come out and check the pool within 1 month.
that would have been done, I'm sorry, when this stupid
Stroke.
stroke,
It happens to several of us.
Yeah.
when we wouldn't have had any of this.
Okay, well, let us get through the motion, then we'll tell you what's going to happen. Okay. Motion made by Ashley for a continuation for 1 month, second by
My mic was off at the time, but I did.
Mr. Remy. Any questions? Further questions? Roll call vote, please.
Member Grant?
Yes.
Member Monis?
Yes.
Member Ozon?
Yes.
Member Richardson?
Yes.
Member Edens?
Yes.
Member Beckles?
Yes.
Chairman Bell?
Yes. Motion carried. All right. Mr. Dragonite, you'll be hearing from our board attorney, Mr. Rogers.
Pardon?
You'll be hearing from our board attorney, Mr. Rogers. You've been granted a 1 month, 1 month stay, so that within that month, the gentleman from Melbourne should be coming to clean your pool.
Yes.
Okay. All right. But we're giving you 1 month until January the 8th of 2018 to get it cleaned.
I don't need a month.
We don't meet
I
again.
wanna
We understand
swim.
that, but we're giving you a month so that he'll come back next month and tell us the pool is clean and it will be withdrawn, okay?
Fine, except I want to swim. I need to do something to get back to being a human being again.
Well, get your pool cleaned.
Mr. Dragonette, real simple. You said you got a pool cleaning man coming Wednesday. After you have your pool cleaned and the water is clean and not green.
Green? Oh, I hear. I'm sorry to interrupt.
If it's clear, you call the code enforcement man to come look. He will then confirm if your pool pump is working and the water is clear. Then you go swim, the problem is over. If you can't get that done by January the 8th, come back and see us and tell us why not, okay?
I have to say one thing, sir.
Okay, go.
You used the word green to color the pool water. And when they do the screens, they take all the screen off. The bottom part of where the screen frame is just practically at soil level. And they have to get that clean or the new screen won't take. And all of that goes into the pool. That's where, because he said, wow, it looked green. That's where that came from. My pool was never green. Well, all right. Whatever you guys say, I've always complied.
Is this your son?
No, I'm the,
That's my brother-in-law.
Brother-in-law.
The pool runs 4 hours a day, the pump does. And
You got to talk into the thing.
the pump,
Not only that, I had the pump rebuilt 5
Mr.
years
Dragonette, if you'll
ago.
hold just a moment. Do you swear or affirm testimony you shall give before this board shall be the truth, whole truth, and nothing but the truth?
yes, sir.
State your name, please.
Robert Rex Edwards.
Okay,
What
get in front of the
are you
microphone.
trying to say into the microphone?
Yes, the pump there works 4 hours a day. And it runs, it's got 3 hydrojets on it. It runs 4 hours a day on there. There's, when Matthew came through, it tore off part of the top of the screen. And all the debris from the next door neighbor started coming in and getting into the pool. And he has about a dozen chlorine boxes over there that he gets from Connor's Pool Supply. And we were pouring that in there and putting the shock in there and everything, trying to keep it clean. But it wouldn't do it because of all that debris it was coming in there every day from the moss and everything else in there. And it finally got behind on him, and where he couldn't afford to do it. In fact, this pool and everything else he's paying for.
Is he going to have a pool cleaning service
Yes.
come?
Yes, we talked to the guy, in fact, before the screening was put in.
I understand, sir. Can you please assist Mr. Dragonette in calling the code inspector after the cleaning
Yes.
service man comes?
I have another thing about that too. August 28th, yes, he was there, but he did not talk to Don. He placed a notice on the garage door. I found the notice.
I understand.
He did not talk to him at all.
but you can have the pool cleaning repair service come, and I would suggest you may have the code inspector come while your pool cleaning service man is there, so they can talk to each other.
It also been hard for him to
Can
talk
I
to him on
request-
August 28th because he was still recovering from the stroke. The stroke occurred on August the 17th.
Okay.
Can
Yes, sir.
I request a different man to come in as a code inspector who isn't friendly with the next door neighbor who has got it in for me for some reason? I know this has nothing to do, but can I ask a different guy? At least talk to me. Tell me what he's saying in here that I never knew about.
Mr. Dragonette, you can ask the city to do certain things, but it's up to the city to decide how they're going to enforce the code.
Yes, I know I didn't have a prayer. Anyways, is that all you people want from you?
Yes, sir. Yes, sir.
We'll
And
see
you
you
will
next
get a
month.
written order in about 2 weeks in the mail.
That's good.
But go ahead and coordinate with the repairs cleaning service, coordinating with the inspector.
I'll give that notice to the cleaning service. They have
Robert
to
Rex
comply.
No, Robert Rex. Yeah.
Anyway, thank you.
Thank you.
I'm sorry I caused this trouble.
Not a problem at all.
Is there anything, am I to go?
Yes, sir, you
Yes.
can go.
Get
Thank
the
you.
hell out of here.
Merry Christmas.
He's not doing bad for 97.
97.
Moving back up to old business. The next item to be heard on your agenda is case number 16-115 for the property located at 5001 River Edge Drive. All right, 5001 River Edge Drive, similar to the case listed just after it. This is a case where we have a property that is undergoing alterations. The owner of the property, Mr. Richard Gaudio, previously came to this board and explained the steps that he had planned for the restoration of the stairway and the exterior of his townhome. If you recall, building department went out to the property, determined that it is not an unsafe structure the way that it currently sat. I verified that it is still not an unsafe structure. The building permit that was previously issued for this property has been extended. The building permit now has an expiration date of June 4th, 2018. Given that the city has authorized the work to continue through that time, I would request that this board continue this case to a period of time that you determine up to the date of June 4th, 2018, when that permit expires.
So move to permit expiration date.
Second.
I would request that you say the date of the June board
June
meeting.
4th, 2018.
Or, no, actually.
the board meeting.
Yeah, so that the date of correction would be in line with the date that you meet for that June 2018.
That should be June the 11th, 2018.
And at that time, if the property has not been corrected, then you should make a determination of the case at that time.
Motion still hold.
I believe I rephrased it correctly, so it just needs a second.
Second? Second, okay. Motion by Ashley for continuation until June 11th, 2018, and second by Ed. Any questions?
I have a question. Do you know if any progress is being made at all, though, other than just pulling permits?
There was some progress made, but then when the hurricanes came through, removed that progress, and now we're back to start over.
And so nothing's been done since September? Okay.
Roll call vote, please.
Member Moniz,
Yes.
Member Ozon,
Yes.
Member Richardson,
Yes.
Member Grant,
Yes.
Member Beckles,
Yes.
Member Edens.
Yes.
Chairman Bell.
Yes. Motion carried. So then we notify they've been extended till June 11th, 2018.
The decision will state that, yes.
Thank you.
I have just found it on my upside down, backwards, every page agenda. As to Goreo is on the second page, second case. Now, what are we doing again? I'm having trouble keeping up.
I'm sorry. The board moved to continue this case until June 11th, 2018.
He was given an extension on his permit till June 6th,
Fourth.
2018. June what?
June
4th,
4th.
2018.
Thank you.
You're welcome. Next case.
The next case I'm looking at is number 17-44 for the property located at 4605 Alpine Lane.
We've heard from this one a few times.
Yes. You may recall Mr. Gerald Smaller was the gentleman corresponding with Mr. Crisco from Australia.
Oh, yeah.
Mm-hmm. Okay.
This property had a permit to perform the demolition. The demolition has been completed. The case was continued until this date to ensure that compliance was achieved, which it has been. I have Officer Crisco here to provide testimony that the demolition is complete. Therefore, the city wishes to close this case that due to the fact that it is in compliance.
Wow, nice. Do we need to hear his testimony? I mean, if the city wants that, do we need to hear the testimony?
The city presents its case as they wish to present it. We will hear what the city wishes to present.
Okay.
Please
the city
proceed.
wants it closed.
This case has previously found that the costs were assessed, and unless the board determines that there is any change with that, I would need a motion to close this case, and compliance was achieved as of the date of October 20th, 2017, when the demolition was complete.
October what?
October 20th, 2017.
So moved.
Second.
Okay. Motion by Gina, second by Mr. Richardson. Any questions?
Mr. Richardson.
Ms. Richardson. Oh.
Joe.
Roll call vote, please.
Member Ozon?
Yes.
Member Richardson?
Yes.
Member Edens?
Yes.
Member Beckles?
Yes.
Member Grant?
Yes.
Member Moniz?
Yes.
Chairman Bell?
Yes. Motion carried. Got it. Anything?
And that constitutes an order finding compliance as you requested?
Correct.
As to the cost that the defendant was ordered to pay, what was your request in that regard?
I said that they were previously assessed, and just reminding the board that that has already been determined for this case, that the costs were assessed, and they have not been paid, but they were assessed against this property.
Based upon the board's decision finding compliance, unless the board wishes to readdress costs, the costs remain outstanding.
The next case on your agenda, number 17-133, for the property located at 3308 South Hopkins Avenue. This case was previously continued and is now in compliance. The city wishes to withdraw this matter.
No further action required in that the board has not made a finding of fact of violation.
So we're good to go.
Yes.
Let's go.
Case number 17-159 for the property located at 920 Cheney Highway. Again, was previously continued and is now found in compliance. The city wishes to withdraw this matter.
No action required, no findings of fact previously, case dismissed.
Yes. Keep going, Chelsea, on a roll.
She got a blue folder.
The next case on your agenda is number 17-163 for the property located at 1650 Whispering Hills Road. I have Officer Hutchings here to provide testimony regarding this case. Officer Hutchings, did you have an opportunity to inspect the premises at 1650 Whispering Hills Road to determine if the property is in compliance?
I did.
And did you find this property in violation of the Titusville Code of Ordinances?
Yes.
What was the nature of the violation?
1223 and 1326, both overgrowth and debris.
And did you provide notice of the violations to the owner of record by first class and certified mail, as well as posting the same on the property and at City Hall?
I did.
And do you have a proof of mailing and an affidavit attesting to the notice?
Yes.
Please submit the proof of mailing and an affidavit attesting to notice into evidence as Exhibit Number 1.
Please both go. Just
No, neither one. This is a decision. Yeah.
Now, we did this all before, right? For both of these cases.
Yes, my mistake here. I have already entered all of this evidence. The property is not in compliance as the violation still exists. And Officer Hutchings, when was your most recent inspection of this property?
This morning.
And did you determine that both of the violations still exist on this property?
Correct.
Do you have any photographs that you would like to show the board?
If the board would like to see as such.
Yes, please.
There.
This is a vacant piece of property.
Yes,
right?
remember this is where that apartment complex stood on the corner of Park Avenue and Barna.
That's where it used to.
Everybody get a chance to see? Where's she still?
And you can submit those two photographs into evidence for the record. Does the board have any questions for staff?
Have you made any contact with any owners since the last meeting? There's been no correspondence at all, period, ever, in this
Correct.
whole entire situation?
Correct.
The banks don't usually communicate with us, do they?
Sir?
Banks are hard to communicate with.
Oh, yeah, this was a different defendant at the time, wasn't it? Wasn't this in a personal name?
No.
No, this was previously Citibank, and I did look at the taxes this morning. The taxes are due from 2014 through 2017.
Oh, wow.
Thank you.
Is that a paved road that's going through there?
I think it's the foundation.
Yeah.
Used to be an apartment complex.
Or the
Sir?
driveway.
Oh, that's, okay. I know where it is, yeah, there used to be an apartment right there.
It's probably the parking lot you're looking at.
Okay.
This property was previously demolished, I think somewhere around 2010, and the slab remains on
Yeah,
site.
That's correct.
It's burned.
Any questions?
Was there a cost recovery statement for that?
Yes, we assessed them for $339.82. The only, I have no problem finding a fact here. It's just, I hate imposing the daily fines on the investors, because that's eventually what it's gonna boil down to. This tax deed is gonna sell, and whomever buys it and tries to improve is gonna end up getting the win, spending the money on resolving this lien. It won't be who let it get into this state. I'd be happy to pay the city for their for their administrative costs, but
They've already been assessed anyway.
that's about all I feel comfortable with.
Well, but that's not our responsibility to determine how much an investor pays for a property or what cost, or that's
Well-
for them to come to negotiate with the attorney if they want to try to work on the fees.
Our
We're trying
interest
to
is
see-
compliance, and we use these fines to entice people to comply. We're not going to entice Citibank to comply by daily fines. They haven't responded to anything. And so passing this to a possible investor that could beautify that property instead of leaving it a vacant lot makes zero sense whatsoever.
But you still, if you're a property owner, you have a responsibility to take care of your property.
But we can't punish
Responsibility to
Citibank.
the-
That's who should be punished, not the guy that's going to come in and build something new on the property.
All we can do is find the owner of record.
Citibank foreclosed on this property and has not paid the taxes since they took that property from the prior owner, but during that foreclosure, The city was wiped out of previous code enforcement action. You never know when the city will get wiped out, and you never know when the new owner will take the property. So there's a lot of variables looking forward. It's easier to look back and see what has happened against the property, and that's part of the history that I know here is that there's been foreclosure, that this property's been neglected, and that it's currently in a state of violation, and that you need to determine what to do based on the outcome or based on the current status of those violations.
Well, my only point is creating tens of thousands of dollars of liens is not going to entice anybody to walk in there and beautify that instead of leaving
But you
it a
can go as
lot,
low as $50 a day per violation, as high as $250.
which we've read off $50,000 judgments for in the long run.
But like I said before, but that's up to the investor to come negotiate with the city attorney and negotiate on whatever's outstanding.
Don't they still have to sign up on a registry of some kind? And part of that registry business is for them to keep it in
The
compliance?
registry is actually on residential, not on apartments.
Oh, okay. Well, maybe we ought to change that then.
And this particular property's not in there.
But it's their obligation to keep it somewhat in compliance. If they would foreclose on it, correct? Or they should.
The owner of the property is the one that's responsible to maintain it, and the vacant property registry is one that is a tool that we use to get a contact person to do that property maintenance, but it's not 100% every time, so there's always situations where we don't have maintenance, and I think that the situation here is it's a vacant lot that's not listed.
All right, I need a motion.
I'll do it.
Do it.
Okay. I move that the board issue the following findings of fact in case number 17-159 relating to the defendant Space Coast Rental.
No.
No. The one,
Wait, okay, let me start over. I move that the board issue the following findings of fact in case number 17-163 relating to the defendant Citibank N.A. trustee. The defendant continued to be in violation of the following sections of the Code of Ordinances of the City of Titusville on November 11, 2017, Section 12-23 by reason of junk and debris, and Section 13-26 overgrowth.
I think you mean December 11th.
You need December the 11th.
All right, December 11th.
Well, I don't want to go back a month.
Second.
Motion by Gina, second by Ed. Any discussion? Roll call vote, please.
Member Beckles?
Yes.
Member Edens?
Yes.
Member Moniz?
Ed?
Yes.
Member Ozon?
Yes.
Member Richardson?
Yes.
Member Grant?
Yes.
Chairman Bell?
Yes. Next motion, please.
I move that the board issue its final judgment assessing fine and imposing lien relating to the defendant Citibank N.A. trustee based upon the findings of fact issued this date, and that the judgment contain the following provisions. The defendant is assessed and ordered to pay a fine of $50 per day per violation, and the fine shall commence on December 11, 2017, and shall continue until the code violations have been corrected to the written satisfaction of the code enforcement officer.
Second.
All right, motion by Gina, second by Ed. Any discussion? Roll call vote, please.
Member Grant?
Yes.
Member Moniz?
Yes.
Member Ozon?
Yes.
Member Richardson?
Yes.
Member Edens?
No.
Member Beckles?
Yes.
Chairman Bell?
Yes, motion carried. Next case, please.
The next case on your agenda is number 17-164 for tax ID 223065 Whispering Hills Road. I'd like to invite Officer Hutchings back to the podium to provide testimony on this matter. Officer Hutchings, the board previously found violations to exist on this property and ordered the defendant to bring the property into compliance on or before December 11, 2017, and to pay the costs of $339.82. The property is not in compliance as the violations still exist. Officer Hutchings, have you re-inspected the premises at tax ID 223065 Whispering Hills Road to determine whether the owner has brought the property into compliance?
I did, and in fact, it's not in compliance.
What violations still exist on this property?
The same as existing with the 1223 and the 1326, again, overgrowth and debris.
Does the board have any questions?
This is that other piece of vacant property?
Correct, sir.
Okay, I remember.
Do you have photographs to display?
I did, if the board would like to see.
Go ahead.
What is the status of the taxes?
They are also unpaid, but I don't have the period of time frame in my notes. You can submit the photographs into evidence. Does the board have any other questions?
I was thinking about something else. Did you check it today? Was it today your last inspection?
Yes, ma'am.
Okay, so I thought, just want to make sure.
So before we do this all over again, I just want to make sure that I know where everybody's coming from. Do you think that Citibank will suffer the fines imposed? Or
Well, no, we're not on Citibank. We're off that
Oh,
one.
okay. So Richard Wellbrock Estate. Do you think that they will pay those fines, or are we all okay?
That's
not-
not
that's not our
future, and
prerogative.
that's not our
That's not our
purview to discuss.
We
We're
have the
not- we're not
ability
here
to
to
impose a daily
represent
fine to encourage compliance, right? So the only reason to impose a daily fine is to encourage compliance. And if we know that we'll never get compliance from somebody who hasn't even paid the tax bill for the last few years to ensure their property rights, do we know that we're passing along to the next person, and is that okay with everyone? Or is there an assumption that it will stick with the defendant that we're looking at?
We're
Mrs.
not here to
Edens, wait a minute.
represent
We're
investors.
going way off track. You're making assumptions without a factual basis. You don't know whether they will or they won't. You don't know the status of this estate or not. You're making assumptions that are not valid without factual basis. We don't need to do that. We need to consider the facts before us, those facts only, and make a ruling as determined by the evidence and the law. Making speculation as to who might or might not buy or might not buy is irrelevant.
Well,
why are you taking up the board's time with these questions?
A few months ago, you took a moment to explain to us that most of these end in a tax deed sale, and they don't actually go back to the original people who we are issuing these fines to.
But this is a
If it's foreclosed upon, that is correct, or if there is a tax deed sale, that is correct. What relevance does that have whether or not there's a code violation on the property?
We can assess that there's a code violation. I mean, we can establish that there's a violation. We have, hands down. My question is, what good do we do our entire city as we continue to impose fines on the next person
This is
coming
a
along?
recourse that we've been given to address properties that are in violation.
And if I may, Ms. Edens, if any interested person wishes to come before this board at any time and request reconsideration due to new evidence, the board can hear that testimony and that evidence. So you're not barring anyone from any right anyone on the planet may have. You're making assumptions what they might do or might not do, and we don't even know who they are. Concern about real estate prices is not a valid concern for the board to worry about.
It's about compliance. And if there's
Yes.
no one to get into compliance, then we're doing it in vain.
We don't know the status of the estate in this case at all. No evidence has been presented as to this estate that I'm aware of.
And it's not our purview to do that anyway. We're here to establish the facts that are related to what we know. And it may keep somebody else from doing it again, bottom line. All right, you've heard the, is there a motion on the? A motion on case number 17-164.
Hasn't been one yet.
I'll make a motion.
Go ahead.
I'll attempt to make a motion. I move that the board issue the following finding of fact in case number 17-164 relating to the defendant Richard Wellbrock estate of Michael Magnet, care of Teresa A. Wellbrock. The defendant was properly notified, is this correct, of the violation as alleged in the complaint. The defendant is the owner of or in possession of the real property located at...
This is supposed to be continuing, right? This
Yes.
is, yeah, so this is
Thank you.
motion for order to correct.
Thank you.
Or no, backside, yes,
Second
this is
reading.
the continuing violation.
Thank you. That's what I was asking for some guidance. I move that the board issue the following final facts for case number, backing up and starting again, 17164, relating to the defendant Richard Wellbrock estate in Michael Magna, care of Teresa A. Wellbrock. The defendant continued, is that correct, to be in violation of the following sections of the Code of Ordinances of the City of Titusville
On the state.
December 11th, 2012.
2017.
December 11th, I'm sorry, 2017, 12, 23, and 13, 26.
That's adequate.
Thank you.
There's a second.
Second.
All right, motion by Sandra, second by Ed. Any discussion? Roll call vote, please.
Member Moniz,
Yes.
Member Ozon,
Yes.
Member Richardson,
Yes.
Member Grant,
Yes.
Member Beckles,
Yes.
Member Edens,
Yes.
Chairman Bell.
Yes. Motion carried. Next motion, please.
Yes.
I move the board issue its final judgment, assessing fine and opposing lien relating to the defendant. Do I need to replace the name again? Based upon the findings, the fact issued this date, and the judgment containing the following provision. The defendant is assessed in order to pay a fine of $50 per day for the violations of each violation. The fine shall commence on today's date, which is December 11th, 2017, and shall continue until the code violations have been corrected to the written satisfaction of the code enforcement officer.
Second.
Motion by Sandra, second by Gina. Any discussion? Roll call vote, please.
Member Ozon,
Yes.
Member Richardson,
Yes.
Member Edens,
No.
Member Beckles,
Yes.
Member Grant,
Yes.
Member Moniz,
Yes.
Chairman Bell.
Yes. Motion carried. Next case, please.
The next case on your agenda is number 17-167 for the tax ID 2204680, located on Elizabeth Avenue. I'd like to invite Officer Hutchings to join me at the podium. The board previously found the violation of overgrowth to exist on this property and ordered the defendant to bring the property into compliance on or before December 11th, 2017, and to pay the costs of $339.82. The property is not in compliance as the violation still exists. Officer Hutchings, have you re-inspected the premises at tax ID 2204680 Elizabeth Avenue to determine whether the owner has brought the property into compliance?
I did, and in fact, it was not in compliance.
What violation still exists?
The overgrowth.
Do you have any photographs?
I did.
Would you like to show the board? Please submit the photograph into evidence.
Oh, stick.
It's coming down. And have you had any contact with the owner?
I have not.
Does the board have any questions?
I have a question. Have we heard about these people before, like several years ago, a couple of years ago?
It's possible. I didn't do any research on prior cases against this entity.
I think so.
This is a, shall I use the word functioning prayer house?
If it is, it would be an open-air prayer house, sir.
What's a vacant property?
Yes, sir.
Oh.
I think.
Oh, yeah, that's your yardstick.
Thank you.
So this is a continuation.
This is second reading. We're all on second readings now. Okay. Anybody want to do anything?
I will, since I did it the last time, I'll try it again.
Go, Sandra.
I move that the board issue the following finding of fact in case number 17167 relating to the defendant Deliverance Prayer House. The defendant continued to be in violation of the following sections of the Code of Ordinance of the City of Titusville on December 11, 2017. And that is Section 1326, overgrowth. I move.
Second.
Okay. Motion by Saunders, second by Ashley. Any questions? Roll call vote, please.
Member Richardson?
Yes.
Member Edens?
Yes.
Member Beckles?
Yes.
Member Grant?
Yes.
Member Moniz?
Yes.
Member Ozon?
Yes.
Chairman Bell?
Yes. Motion carried. Next motion, please.
I move the board issue its final judgment assessing fine and imposing liens relating to the defendant based upon the findings of fact issued this date and the judgment containing the following provision. The defendant is assessed in order to pay a fine of $50 per day for the violations. The fine shall commence on December 11th, 2017 per day for the violation of all sections. Fine shall commence and shall continue until the code violations have been corrected to the written satisfaction of the code enforcement officer.
Second.
Second by Ed, okay.
When do the fines commence?
12/11.
Today.
Motion by Saunders, second by Ed. Any questions? Roll call vote, please.
Member Edens?
No.
Member Beckles?
Yes.
Member Grant?
Yes.
Member Moniz?
Yes.
Member Ozon?
Yes.
Member Richardson?
Yes.
Chairman Bell?
Yes. Motion carried. Next case, please.
The next case on your agenda is case number 17-168 for the property located at 1605 Whispering Hills Road. I've invited Officer Hutchings back up to provide testimony regarding this case. Officer Hutchings, have you, let's see here. The board previously found violations to exist on this property and ordered the defendant to bring the property into compliance on or before December 11th, 2017, and to pay the cost of $339.82. Have you had an opportunity to re-inspect the premises at 1605 Whispering Hills Road to determine whether the owner has brought the property into compliance?
I did. This morning is still in compliance. Or I'm sorry, I apologize. In compliance.
Not
in compliance. There we go.
And what violation still exists on the property?
The 1326, the overgrowth.
And do you have a photograph to show the board?
I do.
Please submit the photograph and evidence.
Dead trees, yeah. Where? Could be, though.
Does the board have any questions?
Thank you.
Anybody want to make a motion? Go ahead.
Just make sure I'm on the right page. I move that the board issue the following finding of fact in case number 17-168. relating to the defendant Ernest E. Cadwell. The defendant continued to be in violation of the following sections of Code of Ordinance of the City of Titusville on December the 11th, 2017. Section 13-126 by reasons of overgrowth.
Back up, Ed, it's not 126.
26, I'm sorry.
Second.
All right, motion by Ed, second by Joe. Any questions, concerns? Roll call vote, please.
Member Beckles?
Yes.
Member Edens?
Yes.
Member Monis?
Yes.
Member Ozon?
Yes.
Member Richardson?
Yes.
Member Grant?
Yes.
Chairman Bell?
Yes, motion carried. Next motion, please.
I move that the board issue the final judgment assessing fines and imposing liens relating to the defendant, Ernest E. Cadwell, based upon the finding of the fact issued this date, and that the judgment contained the following provisions. The defendant is assessed in order to pay a fine of $50 per day for the violation of section 13-26, and for each section. The fine will commence on December the 11th, 2017.
Second.
Okay, motion by Ed, second by Joe. Any discussion? Roll call vote, please.
Member Grant?
Yes.
Member Monis?
Yes.
Member Ozon?
Yes.
Member Richardson?
Yes.
Member Edens?
No.
Member Beckles?
Yes.
Chairman Bell?
Yes, motion carried. Next case, please.
Before I move on to the next case, for the board's education on a matter that you have been talking about, the tax deed sales, I don't want to delay you guys too much, but I just want to let you know that they happen every month. And last Friday, many callers were looking for information about the tax deeds that are going to be sold on Thursday, the 14th. And there's 2 properties that are single-family residential that are going to the tax deed sale. So I'm very fluent in the history that they have had before Code Board. They're both relatively nuisance properties. One of them has liens over $300,000 that I'm going to negotiate down, I'm sure. And the other is 1605 Whispering Hills Road, which you just dealt with. And the owner could redeem his taxes, and I may not deal with it. And then, in which case, they would be responsible for the violation that you have just imposed a daily fine for. Or it will go to the new owner on Thursday, and then they'll call me, and I'll tell them that the first thing they need to do is take care of the overgrowth, because there's a running fine that there wasn't before today's date. And so every case is different. We don't know how things will end up, but this is one where I expect to see a new owner by the end of this week, and I appreciate all the work that you do in the deliberation. I know that it's a very difficult decision with everyone, but you need to look at the case as it sits before you today, and I appreciate your board attorney's guidance on that matter as well. I'll move on to the next one now. Case number 17-171 for the property located at 405 Garden Street. Again, I'm going to invite Officer Hutchings up for his testimony. This is case number 171. The board previously found violation of overgrowth to exist on this property and ordered the defendant to bring the property into compliance on or before December 11th, 2017, and to pay the cost of $339.82. This property is not in compliance as the violation still exists. Officer Hutchings, have you had an opportunity to reinspect the premises at 405 Garden Street?
I did.
And did you determine whether the owner has brought the property into compliance?
It is not in compliance.
What violation still exists?
The 1326 overgrowth.
Do you have any photographs?
I do.
Thank you. Please submit the photographs into evidence.
In this case, someone did sign for the certified mail, yes?
Yes.
This one's been here a lot of times.
Correct.
I just don't understand what we can't, I just don't understand what we can't we do something more than this circle of
In
what
the
we're
past,
doing?
the owner has always brought this property into compliance. This is a different history, or a different pattern, that it's breaking the pattern, if you will, because in the past, code enforcement notices has initiated the owner to go out and clean the property, which has not happened here this time.
This has to be the 8th time or whatever.
It very well could be.
This property is consistently a problem.
Does the board have any questions of staff?
Thank you.
Is that all we can do, is just give them a fine for cutting the grass? That's it, right?
Yep, that's all we can do.
Who wants to make a motion?
I'll make a motion.
Go ahead, Jean.
I move that the board issue the following findings of fact in case number 17-171 relating to the defendant Paxir Incorporated, care of Abdul Malik. The defendant continued to be in violation of all of this, to continue to be in violation of all sections of the Code of Ordinances of the City of Titusville on November 11th, I keep saying November, on December 11th, 2017, as previously determined by this board.
Second.
Motion by Gina, second by Ed. Any questions? Roll call vote, please.
Member Monis?
Yes.
Member Ozon?
Yes.
Member Richardson?
Yes.
Member Grant?
Yes.
Member Beckles?
Yes.
Member Edens?
Yes.
Chairman Bell?
Yes. Motion carried. Next motion, please.
I move that the board issue its final judgment assessing fine and imposing lien relating to the defendant Paxir Inc., care of Abdul Malik, based upon the findings of fact issued this date, and that the judgment contain the following provisions. The defendant is assessed in order to pay a fine of $50 per day per violation, as set forth in the findings of fact herein. The fine shall commence on December 11, 2017, and shall continue until the code violations have been corrected to the written satisfaction of the code enforcement officer.
Second.
Second by Ed, okay. Motion by Gina, second by Ed. Any questions? Roll call vote, please.
Member Ozon?
Yes.
Member Richardson?
Yes.
Member Edens?
Yes.
Member Beckles?
Yes.
Member Grant?
Yes.
Member Monis?
Yes.
Chairman Bell?
Yes. Motion carried. Next case, please.
The next case on your agenda is 17-173 for the property located at 1000 Williamsburg Drive. The city wishes to withdraw this case due to foreclosure activity.
Due to what? Court closure?
Foreclosure.
Oh, foreclosure. Do you need a motion? Do we need a motion for that, Mr. Rocker?
No, no
Okay.
motion.
Thank you.
Next, we have case number 17-174 for the property located at 3095 Finsterwald Drive. I have Officer Lewis here to provide testimony regarding this matter. The board previously found violations to exist on this property and ordered the defendant to bring the property into compliance on or before December 11th, 2017, and to pay the cost of $375.04. Officer Lewis, the property is not in compliance as the violations still exist. Have you had an opportunity to inspect the premises at 3095 Finsterwald Drive?
Yes, I have.
And is the property still in violation?
It's still in violation as of this morning.
And what violations still exist?
13-26 overgrowth and 13-28 dead trees.
Do you have any photographs?
Yes, I do.
What does the photograph depict?
This is a vacant lot that is overgrown, and if I can get it right, this tree right here, the large pine tree that's dead.
Do Do you have any additional photographs?
No.
Please submit the photograph into evidence. Does the board have any additional questions?
And it's a vacant lot, not a house on it?
Vacant lot, yes, ma'am.
Okay.
It's been cleared for development, but nobody has built anything on it yet.
Officer Tuggle says she's had communication with this person in previous cases, but not this one. Do you have any idea when the last case was she communicated with her?
No, I do not. This time evidently she's had no contact from the owner. I do know that one time before myself, I have dealt with this property and it got taken care of, so I don't know what went wrong this
Within the last 5 years?
It's approximately 2016.
Okay.
Do you have a record of the first inspection that this property was cited in this case?
Yes, I do. It'll be June 21st, 2017.
Thank you.
Any further questions of the staff? Okay, we'd like to make a motion.
I'll do it.
Go ahead, Gina.
I move that the board issue the following findings of fact in case number 17-174 relating to the defendant Arlene White in trust. The defendant continued to be in violation of all of the sections of the Code of Ordinances of the City of Titusville on December 11, 2017, as previously determined by this board.
Second.
Motion by Gina, second by Ed. Any discussion? Roll call vote, please.
Member Richardson?
Yes.
Member Edens?
Yes.
Member Beckles?
Yes.
Member Grant?
Yes.
Member Monis?
Yes.
Member Ozon?
Yes.
Chairman Bell?
Yes. Motion carried. Next motion, please.
I move the board issue its final judgment assessing fine and imposing lien relating to the defendant Arlene White in trust based upon the findings of fact issued this date, and that the judgment contained the following provisions. The defendant is assessed in order to pay a fine of $50 per day per violation as set forth in the findings of fact herein. The fine shall commence on December 11, 2017, and shall continue until the code violations have been corrected to the written satisfaction of the code enforcement officer.
Second.
Motion by Gina, second by Ed. Any discussion? Roll call vote, please.
Member Edens?
Yes.
Member Beckles?
Yes.
Member Grant?
Yes.
Member Monis?
Yes.
Member Ozon?
Yes.
Member Richardson?
Yes.
Chairman Bell?
Yes. Motion carried. Next case, please.
All right. The next case on your agenda is number 17-180 for the property located at 3135 South Casper Place. I have Officer Lewis here to provide testimony regarding this item that you have not previously heard before. Officer Lewis, did you or another member of the Code Enforcement Department staff have an opportunity to inspect the premises at 3135 South Casper Place?
Yes, we did. I inspected it this morning. The original inspection date was August 17th, 2017.
Who performed that inspection?
That would be Inspector Ashley Tuggle, Code Enforcement Officer Ashley Tuggle.
And did the code enforcement officer find this property in violation of the Titusville Code of Ordinances?
She did.
And what was the nature of the violation?
Sorry, it's not my case. Be 13-73 inoperative vehicles and 20-60A, which would be parking regulations. Specifically construction equipment in a residential neighborhood, residential area.
Section 20-60 of the City of Titusville is entitled On-Street Parking Regulations, which says, districts in which parking is prohibited. It shall be unlawful for any person, either as agent, owner, occupant, lessee, tenant, or otherwise, to park, store, deposit, or allow, cause, or permit to be parked, stored, or deposited on any public or private property in any residential zoning district in the city, any road tractor, semi-trailer, truck tractor, or any combination thereof, or any other truck or special mobile equipment or other heavy equipment of whatever type, size, or nature.
This isn't the same case where the man testified last month.
I believe it is. This case was previously continued from last month. And this is the one case last month that had these violations. And he was present, and that was why it was continued. Did the city provide notice of the violation to the owner of record? And yes, you have seen the notices that were submitted, and I'm re-entering this evidence into the record as it was not found here. Here we're going to see the notice of violation that was presented to the record. Do you have the proof of mailing and affidavit that shows that the notice of violation was sent? Can you please submit that into evidence?
Let her go too.
What is this?
And even though we read that and it says something about on-street parking, we're really not concerned about on-street parking. That's not happening. It's just that it's a commercial vehicle.
The tractor vehicle, correct. On site. And Ms. Officer Lewis, can you tell us when did a follow-up inspection occur after the initial August 17th inspection was taking place?
On August the 15th, 2017.
That's before.
When was the subsequent inspection?
I'm sorry.
I think
I'm
we gave
sorry,
him
no-
time to get a permit. Do you have any information about whether he was issued a permit?
Has the owner of the property contacted Code Enforcement Department since last month's Code Board meeting?
Not to my knowledge. 9/26, I'm sorry, 9/6/2017 was the subsequent inspection, was the re-inspection.
Okay.
Off the initial, yes, okay.
And at the subsequent inspection, did the city code enforcement officer Tuggle take photographs of the property and determine that there was a continuing violation?
Yes. That's the one for car.
Do we have anything after November 13th, 2017? Because we were brought to date on November 13th.
Have you had any communication with the owner of the property since last Code Board?
I have not.
I have not either. Manager Tolleson, have you heard from the owner of the property?
We have not.
Has anybody inspected it to see whether he parked any of the equipment in the garage?
It has been re-inspected today.
Almost there. All right. So based upon the previous inspections, did the code enforcement officer file a complaint?
Yes, she did.
And do you have a copy of the complaint that was issued to notice this hearing to the owner of record by first-class certified mail posting the same on the property and at City Hall?
Yes, I do. Yes, you do.
Please submit the affidavit into evidence as exhibit number 2. And where are your photographs from this morning's inspection?
This morning, I have one photograph.
Go ahead. What does this photograph depict?
This photograph here depicts a violation of 20-60, which is commercial equipment parked in a residential neighborhood. According to Inspector Tuggle's notes, the backhoe that was there is gone, the mixer is there, and the vehicle is still in violation.
The van that he said was tagged, that's what we're talking about?
Is this van still on the site?
This van is still on
Can you put this
site.
on the overhead, please?
Yes.
And that is a current, can you read those dates?
The date of the inspection sticker is expired on the tag of this minivan. It is September 2017. And this picture will be passed down the line. But the inoperative vehicles prohibited is one of 2 violations that's cited under this case. The van's plate is expired, and that is a clear violation of that section of the Code of Ordinances. The second violation that's listed, Section 20-60, regarding parking regulations, relates to the first photograph that Officer Lewis demonstrated that there is construction equipment parked in the yard that is not authorized to be used there. Please submit the 2 photographs you just displayed into evidence as exhibit number 3.
Did he testify last time that he had already paid for the van? He just hadn't applied the sticker, or was that the other vehicle case?
He said he had the sticker, we just need to put it on. He hadn't put it on.
He was gonna put it on.
Officer Lewis, do you have information regarding the registration?
The registration on the van, as of 1:30 PM today, it had not been renewed.
Mr. Tolleson, did you have additional testimony to provide to the board?
I did. Ms. Edens asked about the permit. Yes, he did testify to the fact that he was going to get a permit, but it has no relation to the equipment that's still on site.
Well, we said that some of the equipment would be allowed if he had an open permit, and then he said he got denied about the palmetto berry permit, so he was going to try a different avenue, but he's made no attempt to.
No, he has achieved a permit, but it's for a roof. That piece of equipment has nothing to do with the roofing permit.
Oh. And so that's specific. Our statute actually reads like that it needs to be.
No, the building department would verify it, which was verified with the building department. Would you use that to re-roof a home? No.
It's a bush hog, right? That's
No,
what we're
it's a
looking at?
cement maker.
Oh, a cement mixer?
Mr. Tellison, if you'll raise your right hand, do you swear or affirm that the testimony you just gave and will give hereafter in the future during this board meeting is the truth, the whole truth, and nothing but the truth? Thank you. Mr. Lewis, these 2 photographs were taken on what date?
The picture right there in your hand was taken this morning. The picture there, to be honest with you, sir, I do not know.
Okay, I have a question. You're saying that the picture that indicates that the license plate on the car is expired?
Yes, and that information was also verified as of 1:30 this afternoon that it continues to not be renewed.
Thanks. I thought that's what you said. Thank you.
Mr. Rogers, in answer to your question there, the picture of the license plate, I can guess that picture was taken on September 6th of 2017. That was her re-inspection date.
Thank you.
Although at that point it wasn't expired yet. But it was dismantled, right? There were tires off of it at the time.
No, I think you're confusing that with some other case.
I think you're confusing that with another case. But as of September 2017, it was expired.
Okay.
And the date that Mr. Lewis just stated was September 2017.
At the time of the inspection and the time of the re-inspection, and as of this morning, the left rear tire on the vehicle was flat.
Okay. All you do is put it in the garage.
Yes.
Any further questions? May I want to make a motion?
Yes.
Go.
This is the first time around, right?
Second time.
We continued it for a month. It's first reading.
Oh, okay.
First time?
Yes.
First time, yeah.
Okay, I thought it was on the right page. I move that the board issue the following finding in effect in case number 17-180 relating to the defendant Lee Johnson and Carla Johnson. The defendant is the defendant was properly notified of the violation as alleged in the complaint. The defendant is the owner or in possession of the real property located at 3135 South Casper Place, Titusville, Florida. The defendant is in violation of all sections of the Code of Ordinance of the city of Titusville listed in the complaint.
Second.
Second by, okay. Motion by Ed, second by Gina. Any questions or any discussion?
Yes, was there a cost recovery for this?
In my notes, I had 392.65.
I'm sorry, say again?
I said,
I don't have one.
the cost, I'm saying from my notes from
your
the
notes.
last previous meeting, it was 392.65.
For the benefit of the board, the decision of the board from last month's meeting does indicate that an exhibit for cost recovery was submitted in the amount of $392.65. 4 photographs were submitted, in addition to the notice of violation and affidavit of posting, notice of hearing, complaint, and affidavit of posting. So those documents were submitted to the board last board meeting. Then the board elected to continue the case until this monthly board meeting.
And I would be happy to resubmit the cost recovery statement at this time. My apologies for not submitting that previously during this case.
Not necessary.
We saw it
It's okay.
last time.
I apparently had forgotten to do it. Wasn't paying attention.
Okay, any further discussion? Roll call vote, please.
Who was the second?
Gina.
Thank you.
Motion by
Member
Ed, second
Beckles?
by Gina.
Member Beckles?
Yes.
Member Edens?
Yes.
Member Monis?
Yes.
Member Ozon?
Yes.
Member Richardson?
Yes.
Member Grant?
Yes.
Chairman Bell?
Yes, motion carried. Second. Next motion, please.
I move that the board issue its order to correct relating to the defendant Lee Johnson and Carla Johnson, adjudging the defendant to be in violation of the sections of Code of Ordinance of the City of Titusville as determined in the finding of the fact, giving the defendant until 9 a.m. on
January 8th,
January 8th, 2017.
18.
To correct, 2018, to correct the violation to written satisfaction of the code enforcement officer, or to appear before this board at City Hall in Titusville on January the 8th.
Yes.
January the 8th, 2018, to show cause why the violation has not been corrected and why this board should not proceed to impose fines for the violation. The defendant is ordered to pay $392.65, which represents the cost incurred by the city of Titusville to bring this case before the board.
Second.
Motion by Ed, second by Gina. Any questions? Roll call vote, please.
Member Grant?
Yes.
Member Monis?
Yes.
Member Ozon?
Yes.
Member Richardson?
Yes.
Member Edens?
Yes.
Member Beckles?
Yes.
Chairman Bell?
Yes.
Can we take 5 soon-ish?
Take 5 minutes. I mean, be back here at 4:30. I mean, please. You cut us off?
Recess?
Recess, yes. Recess. These meetings are getting worse.
Yeah.
Why are they getting worse? They should be getting better. They're getting longer. Don't trip.
Okay, okay. I'm satisfied.
It could be,
Yeah.
no, it could be another year or 2 or 3, depending on how much.
Okay. It's just the 6 cases that we talked about this year.
Patients like it used to, but
Yeah.
things are getting unraveled. And you brought up a
Okay.
before.
Wait till January or February.
And that's got to
Just want to make sure
Okay.
Chelsea back.
I'm not going to
Y'all
bring
ready?
that today.
Can we go back on, please?
try to take care of that.
All right, guys, we all ready to go?
Ready.
Okay, next up on the agenda, we have case number 17-181 for the property located at 1475 Thornton Avenue. The city wishes to withdraw this case due to compliance.
Yay.
And then we have case number 17-183 for the property located at 2300 Southwest Circle. Not as good of news here, but I do have Officer Lewis here to provide testimony regarding this matter. The board previously found the violation of overgrowth to exist on this property and ordered the defendant to bring the property into compliance on or before December 11th, 2017, and to pay the cost of $410.26. The property is not in compliance and the violation still exists. Officer Lewis, have you had the opportunity to reinspect the premises at 2300 Southwest Circle?
Yes, I did.
Is the property still in violation?
Yes, it is.
And what is the nature of the violation?
13-26 overgrowth.
Did you take a picture?
Yes, I did.
Let's see it. It's great contrast. Let's pass it down the line so the board can actually see what this picture looks like. Do your notes reflect any communication with the owner of this property?
No, they do not. I did have there was a call that came in sometime late, I think it was Friday, this past Friday. Came in that one of the investment company called, and we returned our call, left them a message. We have not had a call back yet.
Does the board have any other questions of staff?
Is the overgrowth just the grass, or is it more than just the grass? Is it what is the overgrowth?
It's the entire property, the grass.
Are there shrubs other than just the yard that need to be maintained?
Yes, there's some up around the house also.
Could you see the backyard?
Only a part of it, from where I was at this morning.
Any more questions? May I have a motion, please?
Thank you.
Go.
I move that the board issue the following findings of fact in case number 17-183 relating to the defendant Affidavit LLC. The defendant continued to be in violation of all sections of the Code of Ordinances of the City of Titusville on December 11, 2017, as previously determined by this board.
Second.
Motion by Gina, second by Ed. Any questions? Roll call vote, please.
Member Ozon?
Yes.
Member Richardson?
Yes.
Member Edens?
Yes.
Member Beckles?
Yes.
Member Grant?
Yes.
Member Moniz?
Yes.
Chairman Bell?
Yes, motion carried. Next motion, please.
I move that the board issue its final judgment assessing fine and imposing lien relating to the Defendant Investabee LLC based upon the findings of fact issued this date, and that the judgment contain the following provisions. The defendant is assessed in order to pay a fine of $50 per day per violation as set forth in the findings of fact herein. The fine shall commence on December 11th, 2017, and shall continue until the code violations have been corrected to the written satisfaction of the code enforcement officer.
Second.
Motion by Gina, second by Ed. Any discussion? Roll call vote, please.
Member Richardson?
Yes.
Member Edens?
Yes.
Member Beckles?
Yes.
Member Grant?
Yes.
Member Moniz?
Yes.
Member Ozon?
Yes.
Chairman Bell?
Yes, motion carried. Next case, please.
Next case, number 17-185, for the property located at 24 LaGrange Avenue. The city wishes to withdraw this case due to compliance.
Thanks. Next case.
Case number 17-186, for the property located at 3175 Cheney Highway. The city wishes to close this case due to compliance.
Yay. Let's hope they do this next year. Do we need a motion?
Yes.
Any motion? Okay, got any motion?
So moved.
Compliance was achieved on December 5th,
Second.
for the record.
December 5th, thanks. Motion by Ashley.
Second.
Second by Joe. Any discussion? Roll call vote, please.
Member Beckles?
Yes.
Member Edens?
Yes.
Member Moniz?
Yes.
Member Ozon?
Yes.
Member Richardson?
Yes.
Member Grant?
Yes.
Chairman Bell?
Yes, motion carried. Next, new business, please. Now we start.
First item of new business is case number 17-190 for the property located at 421 Canaveral Avenue. At the beginning, right before this meeting started, an owner presented himself and made promises to the code enforcement officer. The city wishes to continue this case for 1 month to allow him the time to correct.
So moved.
So moved.
Who was the okay. Motion made by Ashley, second by Ed. Any discussion? Roll call vote, please.
Member Grant?
Yes.
Member Moniz?
Yes.
Member Ozon?
Yes.
Member Richardson?
Yes.
Member Edens?
Yes.
Member Beckles?
Yes.
Chairman Bell?
Yes, motion carried.
Case number 17-193, the property located at 2411 and 2413 Talmadge Drive. Again, the owner presented himself at the beginning of this meeting and met with the code enforcement officer, and the city agreed to continue this case for 1 month.
Move we continue?
Yep.
So moved.
Oh, okay.
I made the motion.
Second.
Any discussion? All right, roll call vote, please.
Member Moniz?
Yes.
Member Ozon?
Yes.
Member Richardson?
Yes.
Member Grant?
Yes.
Member Beckles?
Yes.
Member Edens?
Yes.
Chairman Bell?
Yes, motion carried. Next case, please.
For case number 17-196, the property located at 2150 Country Club Drive, the city wishes to withdraw this case due to compliance.
Oh, yes.
Yeah.
I'm surprised. Is that still the same man that we had before? I think so. Never mind then. I don't need complicated answer. Next case.
The next case on your agenda is number 17-198 for the property located at 580 Sunrise Drive. I'd like to invite Officer Lewis to provide testimony regarding this matter. Officer Lewis, did you have an opportunity to inspect the premises at 580 Sunrise Drive?
Yes, I did.
And when was the city's initial inspection?
Initial inspection on this property was September the 26th, 2017.
Who performed that inspection?
Code Enforcement Officer Ashley Tuggle.
And did she find this property in violation of the Titusville Code of Ordinances?
Yes, she did.
What was the nature of the violation?
1326, overgrowth.
Did the city provide notice of the violation to the owner of record by first class and certified mail, as well as posting the same on the property and at City Hall?
Yes, they did.
And do you have the proof of mailing and affidavit attesting to the city's notice?
Yes, I do.
And can you please submit the proof of mailing and affidavit as to notice and evidence as exhibit number 1? And did the city go out and re-inspect the premises to determine if the property was in compliance with the violations as cited?
Yes, it did.
And did you take any photographs of the property during any of these inspections, or do you have any photographs with you that can be described to reflect this violation?
Yes, I do. This morning, I apologize to the board and to the city attorney's office. I missed this one on the agenda. I went out this morning. The property is still in violation. These photographs here were probably taken on her re-inspection on October the 18th. These conditions still exist today. And it's hard to see, but it's grown up really, really bad. Matter of fact, this might be a little easier one to see. You can see how high the grass is.
Do you have more than 2 photographs?
This one right here, yes. This one right here. And here is one more, the other side of the yard.
All right, we've got 3 photographs. Please submit the 3 photographs into evidence for the board's review.
Is this home vacant?
Yes, sir.
Okay.
Have you had communications with the registered owners?
No contact from the owner according to Officer Tuggle's notes.
What's the status of the taxes?
I don't have the tax record. I believe that 2017 is all that's owed, so current status essentially. However, the utility debt is substantial, and the last payment on the utility account was February 2016.
And we think it's been vacant since then?
There's been no consumption on the utility account since February 2016, and the debt is just over $1,000.
Do you know if both parties are alive?
I know that Michael Marafini is deceased. I do not know the whereabouts of Virginia. All right, based upon the city's inspection, did we file a complaint?
Yes, we did.
And did we issue a copy of the complaint and a notice of this hearing to the owner of record by first class certified mail posting the same on the property and at City Hall?
Yes, we did.
And do you have an affidavit attesting to this notice?
Yes, I do.
Please place a proof of notice and affidavit into evidence as exhibit number 3.
It looks very vacant.
And as of this morning's inspection, did the violation still exist?
Yes, they did.
And do you have a cost recovery statement detailing the cost incurred in bringing this case before the board?
Yes, I do.
And what is the amount?
The amount is $358.05.
Please submit the cost recovery statement into evidence as exhibit number 4. Does the board have any further questions?
Any questions for any further questions of staff?
No.
Thank you.
Okay. Motion, please.
Motion?
Yes, ma'am. Yes, please.
Okay, I move that the board issue the following finding of the fact in case number 17-198, relating to the defendant, Michael M. Marfini, and Virginia L. Marfini. The defendant was properly notified of the violation as alleged in the complaint. The defendant is the owner or in possession of the real property located at 580 Sunrise Drive in Titusville, Florida. The defendant is in violation of all the codes, of the section of codes of ordinance of the city of Titusville as listed in the complaint.
Second.
Motion by Ed, second by Joe. Any discussion? Roll call vote, please.
Member Richardson?
Yes.
Member Edens?
Yes.
Member Beckles?
Yes.
Member Grant?
Yes.
Member Monis?
Yes.
Member Ozon?
Yes.
Chairman Bell?
Yes, motion carried. Next motion, please. You okay? Next motion?
Okay. I move that the board issue its order to correct relating it to the defendant, Michael M. Marfini and Virginia L. Marfini, judging the defendant to be in violation of the section of Code of Ordinance of the City of Titusville as determined in the finding of the fact, giving the defendant until 9 a.m. on January the 8th, 2018, to correct the violation to written satisfaction of the code enforcement officers or to appear before the board at City Hall in Florida on January the 8th, 2018, to show cause why the violation has not been corrected and why this board should not proceed to impose fines for the violation. The defendant is ordered to pay $358.05, which represents the cost incurred by the city of Titusville to bring this case before the board.
Second.
Okay, motion by Ed, second by Ashley. Any discussion? Roll call vote, please.
Member Edens?
Yes.
Member Beckles?
Yes.
Member Grant?
Yes.
Member Monis?
Yes.
Member Ozon?
Yes.
Member Richardson?
Yes.
Chairman Bell?
Yes, motion carried. Next case, please.
Next case, number 17-202, for the property located at 4275 Mount Sterling Avenue. The city wishes to withdraw due to compliance.
Thank you. Next case.
Case number 17-207, for the property located at 2000 Cheney Highway. The city wishes to withdraw due to compliance.
That was a big tree.
Was that the one that was fallen over?
Yep.
Big, huge.
Took up some of the parking lot. Next case, please.
For case number 17-210, the property located at 4465 Mount Vernon Avenue, the city wishes to continue this matter for 1 month.
Move to continue.
Second.
Okay, motion by Joe, second by Ashley. Any discussion?
What's the reason to continue?
That was good.
The city wants to continue.
There's been progress working with the owner.
Motion by Joe, second by Ashley. Who was that second?
I did say
Okay.
something. I don't know if I beat anyone
Okay.
else.
Roll call vote, please.
Member Monis?
Yes.
Member Ozon?
Yes.
Member Richardson?
Yes.
Member Grant?
Yes.
Member Beckles?
Yes.
Member Edens?
Yes.
Chairman Bell?
Yes, motion carried. Board Attorney's report.
Yes, I have multiple final judgments to bring to the board's attention. 6 of which I recommend that the board turn over to the city attorney in the city attorney's discretion to commence foreclosure action or other action to compel code compliance. The first case bear with me, is 17-66. The name of the defendant, it's easier to spell, it cannot be pronounced. MWIARLLC is the name of the defendant, a company, limited liability company. In that case, the final judgment was rendered on June 21st, 2017, finding multiple violations of 6-109, 301.3 vacant structure and land, 302.7 accessory structure, fence, 304.7 roofs and drainage, 304.1 general exterior maintenance. A fine was imposed by this board of $100 per day per violation for a total of $400 per day to commence on June 12, 2017. Nonetheless, this case has been settled by the city attorney with the representatives of the defendant for $1,000, so no further action is needed in this case in that compliance has been achieved and the final judgment has been resolved by settlement by action of the city attorney. Next case is 17-68, defendant Salvador F. Rodriguez. Property is located in the prior case, by the way, it was at 4485 Gray Avenue, Titusville. The present case, 17-68, defendant Salvador F. Rodriguez. Property located at 2800 Starlight Drive, Titusville, Florida. Final judgment, July 20th, 2017. Violations 6-109 Property Maintenance Code subsection 102.2, occupied with no active water source. In this case, this board rendered its final judgment imposing the cost as the sole fine and a flat fee of $410.26. To the best of my knowledge, the violations still exist and the fine cost have not been paid. Next case, 17-01, defendant John Franklin Crockett. Property located at 1390 Thornton Avenue, Titusville, Florida. Final judgment, July 20th, 2017. Violation found by the board, 6-109, Property Maintenance Code, subsection 108.1.1, Unsafe Structure. The board imposed a fine of $75 per day to commence on June the 12th, 2017. I have no knowledge of compliance or fine and costs being paid. Therefore, through today's date, 183 days have elapsed at $75 per day for a total fine to date of $13,725. Costs previously assessed, $356.68. Total fine and cost to date, $14,081.68. Next case, 17-50, defendant Ronald C. Mace. Property located at 144 Roosevelt Street, Titusville, Florida. Final judgment, July the 20th, 2017. Violation, 6-109, Property Maintenance Code, 108.1.1, Unsafe Structure. The fine was to commence on May the 12th, 2017. No indication of compliance or fine and cost payment. Therefore, 203 days have elapsed at a fine rate of $100 per day for a total fine of $20,300. Cost assessed, $339.82. Total fine and cost to date, $20,639.82. Next case, 1751, defendant Glenn S. Silvers, property located at 192 Roosevelt Street, Titusville, Florida. Final judgment, July the 20th, 2017. Violations found by the board, 13-26, overgrowth, 1373, inoperable vehicles prohibited. Section 6-109, subsection 108.1.1, unsafe structure. The fine was imposed at the rate of $100 per day for all violations for a rate of $100 per day to commence on June 12th, 2017. Cost assessed, $339.82. No indication of compliance or finding cost payment. Therefore, at 183 days at $100 per day, $18,300 fine to date. Cost $339.82. Total finding cost to date, $18,639.82. Next case, 17-56, Defendant Walter O. Ferrero. Property located at 4100 Alpine Lane, Titusville, Florida. Final judgment, July the 20th, 2017. Violation 6-109, subsection 304.1, general exterior maintenance. Subsection 304.10, stairways, decks, and porches and balconies in disrepair. Fine imposed, $100 per day per violation for a total of $200 daily to commence on July the 10th, 2017. No indication of compliance or finding cost payment. Therefore, 155 days have elapsed at $200 per day. Total fine to date, $31,000. Cost previously assessed, $375.04. Total finding cost to date, $31,375.04. The final case is 17-76, Defendant Sylvia Chin. Property located at 1620 Hilldale Road, Titusville, Florida. Final judgment, July the 20th, 2017. Violation 13-73, inoperative vehicle prohibited. Fine imposed, $100 per day. The defendant achieved compliance on August the 14th, 2017, with the fine commencing on August the 4th, 2017. Therefore, fine of $100 for 10 days. Total fine, $1,000. And now it's in compliance. But the costs previously assessed and unpaid are $410.26. Total fine and cost outstanding, $1,410.26. Again, all cases, with the exception of the one already settled by the city attorney, I recommend the board authorize me to turn over all 6 cases to the city attorney's office for their discretion in attempting to achieve code compliance.
So moved.
Second.
Motion by Gina, second by Joe, about turning the our board attorney's report over to the city attorney. Any discussion? Roll call vote, please.
Member Ozon?
Yes.
Member Richardson?
Yes.
Member Edens?
Yes.
Member Beckles?
Yes.
Member Grant?
Yes.
Member Moniz?
Yes.
Chairman Bell?
Yes. Motion carried. City attorney's report.
No update, only a big welcome back to your board attorney. We missed you last month.
Thank you.
Yes.
I'm back, and I'm not through yet.
Uh-oh, now what?
We also need to have an election
Sorry.
for the vice chair position of this board. You elected your new chair in my absence last month, Pat Bell. Her seat is now empty as vice chair. I recommend the chairman conduct an election to hear motions for who should be appointed as vice chair.
I'd like to talk to,
You'd like to what? Like to nominate?
nominate
Whom would you like to
Dr.
nominate?
Gina Beckel.
All right, Dr. Gina. Anybody else? Gina, you've been nominated. Any, vote, please. Roll call vote, please.
You need a second before.
Oh, I do. I need a
Second.
second. I thought, oh, okay. Well, I have a motion to nominate Gina and a second, a motion by Ed, second by Joe to nominate Gina for co-chair. Any discussion? Roll call vote, please.
Member Richardson?
Yes.
Member Edens?
Yes.
Member Beckles?
Yes.
Member Grant?
Yes.
Member Moniz?
Yes.
Member Ozon?
Yes.
Chairman Bell?
Yes. Gina, you've been elected co-chair of this wonderful board.
I don't want to be absent.
Right, okay. All right, Chairman's report. The only thing I want to say is thank you and hope the new year's good to us and to everybody there, and a Merry Christmas to whoever's left in here and out there in the audience. Board member report?
I have a report.
All right, go ahead.
I finally contacted Mike Cunningham, and he agreed to attend a lunch on January the 8th.
Oh, okay.
And we'll tell you where that ends up being. You're on your own. There's nobody's gonna pay for it, and we'll keep the, what do you call it? We'll keep the sunshine law in effect for the entire meeting.
I may or may not be here next month.
Oh, yeah.
Yeah, you might have a
So
baby.
I may see you again in February.
Oh, there's been a alternate member reporting about the council?
That's correct.
Yeah.
So when's the actual due date?
I'm due the 10th of January. My first came 3 days early. I'm still hoping on the early side, but not before Christmas. So
Well, not on the day of the 8th when you're in here going to labor.
Right,
No.
all right.
Okay,
Well,
so forbid that.
you guys would just take a break for me for that, right? No big deal.
We'd have to get a
Maybe.
Have to get a motion.
Okay. Huh?
I'm sorry?
But there's only.
Oh, of course. I'll like, have my boyfriend come up and send her home with him or something. But yeah, I'm sure that once we get past the, 1 month mark, we'll go visit all the people and see the things and do the experiences.
And adjourned. Thank you so much. See you next year, if not before.
Merry Christmas.
Before anybody